Bismillah ar-Rahman ar-Rahim. Assalamu alaikum wa rahmatullahi wa barakatuh. Introduction to Paralegalism, Perspectives, Problems, and Skills, 9th edition. Chapter 14. Narrated by Omar Mohsen Ibrahim Fouad. Litigation Support, the Role of the Paralegal. Chapter Introduction. Chapter Objectives. After completing this chapter, you should be able to distinguish between the civil and criminal litigation process, list the major steps in bringing and defending a civil case, diagram the process of bringing a civil case from filing a lawsuit through trial, summarize the major steps in bringing and defending a criminal case, describe the major steps in bringing and defending a case before an administrative agency, explain the different categories of alternative dispute resolution, identify the major roles of paralegals in the pretrial, trial, and appellate stage of litigation, assess the role of the paralegal in the enforcement stage of litigation. What if you are working through the discovery in the Michael Brown case, which is the client we are following in this chapter? Information has been exchanged between the insurance company and the other defendants in the case. Diligently working through the documents, you find a document that you do not recall seeing. It was found in between a pile of documents that were submitted. The document appears to be a medical report showing that Brown's friend, Clay, had a near-fatal overdose of drugs 2 years ago. No one ever mentioned that Clay had a drug problem, let alone was hospitalized for an overdose. Mr. Brown had not been in contact with his friend for years, and their meeting again was by chance. Finding this information is significant, and you know you must bring this to your attorney's attention immediately. You wonder whether this information can be used at either the civil or criminal trials. Especially given the fact that Clay was killed in the accident. You do not know the rules of evidence under these circumstances. Is this the piece of information everyone was hoping for? Mr. Brown has always proclaimed innocence and stated that he knew nothing about the drugs that were under his seat in the car when Clay picked him up. Is this information relevant in the civil, criminal, or administrative proceedings? Research and further inquiry must be done, but you believe this is the break that everyone was looking for in the case. The civil trial is set in 60 days, and you know that time is short, so you must get this information to your supervising attorney ASAP, as soon as possible. Drafting an email of your discovery, you relay all the details to your attorney and wait for instructions as to next steps. You are cautiously optimistic and hopeful that this piece of information will be the turning point in the case. Paralegals are often part of the litigation process, whether it be in the civil, criminal, or administrative context. They can be instrumental in performing the review of discovery documents, and their due diligence is often critical in the success of a case. Sometimes you are the eyes and ears of the attorney with whom you are working. This chapter will follow the Michael Brown case through the civil, criminal, and administrative processes. We will focus on each stage of the litigation process and highlight where paralegals play important roles in that process. You will understand how and why the paralegal is an integral team member in the litigation process and why it is important to master skills needed. You will understand how and why the paralegal is an integral team member in the litigation process and why it is important to master skills needed to be a critical member of the team. 14-1 Introduction. America is a litigious society, meaning we are prone to engage in disputes and litigation. Every year, over 100 million new cases are filed in state courts and approximately 400,000 in federal courts, not including 1.2 million bankruptcy filings in federal bankruptcy courts. Litigation is the formal process of resolving legal controversies through the courts. Administrative agencies can also resolve some legal disputes, as we saw in Chapter 7. In fact, a good deal of litigation begins in administrative agencies, whose decisions can be appealed in court. 14-2 Overview of Civil and Criminal Litigation. Paralegals can perform many functions in assisting attorneys who are litigating cases. Before studying what these functions are, review the following overview of litigation, which will provide a context for understanding the roles of the attorney and paralegal. The overview is presented in the form of a story, the litigation woes of Michael Brown, who finds himself embroiled in a civil trial, a criminal trial, and an administrative dispute. There are two broad categories of litigated disputes: civil and criminal. A civil dispute consists of one private person or entity, like for example a business, sues another private person or entity. Examples: Wheeler sues Gates for negligence after an automobile collision. Ajax Inc. sues Thomas Vine Co. for breach of contract, or one private person or entity sues the government. Examples: a senior citizen sues the Social Security Administration for denial of disability benefits. An inmate sues a state prison for violation of civil rights, or the government sues a private person or entity for a matter other than the commission of a crime. Example: the State Department of Revenue sues the Day Glow restaurant for the failure to deduct state taxes from the wages of servers. A criminal dispute is a legal controversy in which the government alleges the commission of a crime. Examples: a person sells drugs to another person. A person shoplifts goods from a store. A person steals money from the boss's business. (14-2A) The Legal Odyssey of Michael Brown, an anatomy of the litigation process. Michael Brown is a salesman for the Best Bread Company. Several years ago, as Brown was walking home from work, Harold Clay, an old friend from the past, stopped and offered him a ride. They had not seen each other since Clay had moved across country a number of years ago. They carried on an excited conversation as Clay drove. After a few blocks, a car driven by George Miller, a resident of a neighboring state, ran through a red light and struck Clay's car. All three individuals were seriously injured and were taken to a local hospital. Clay died 2 weeks later from injuries received in the crash. Several days after the accident, Brown's boss, Frank Best, wrote Brown a letter. In it, Best said he had learned that the police had found about a half ounce of heroin under the front passenger seat of Clay's car and were planning to charge Brown with possession of narcotics with intent to distribute. Best also stated that several thefts had occurred at the company warehouse recently and that he now suspected Brown of having been involved in them. For these reasons, he decided to fire Brown effective immediately. At least 3 different legal disputes involving Brown could arise out of this fact situation. 1. A dispute among Brown, Miller, and Clay's estate regarding civil liability for the accident. 2. A dispute between Brown and the government regarding the criminal drug charge. 3. A dispute among Brown, the Best Bread Company, and the State Unemployment Compensation Board concerning Brown's entitlement to unemployment compensation benefits. This also is a civil dispute. Each of these disputes could lead to a number of court decisions. The third dispute might involve an administrative decision, possibly followed by 1 or more court decisions, all concerning Brown's claim for unemployment compensation. 1. Civil liability. Brown suffered substantial injury as a result of the crash. This raised important questions. From who could Brown collect damages, which is an award of money paid by the wrongdoer to compensate the person who has been harmed? Who is liable for the accident, meaning who was legally responsible? Was Miller at fault? Clay? Was each of them jointly and severely liable? Determining joint and several liabilities is important as each party is responsible for the wrongdoing together and individually. What this means is that each wrongdoer is individually responsible for the entire debt or judgment. The injured party can choose to collect the full debt or judgment from one wrongdoer or from all of them until the debt or judgment is satisfied. Brown retained or hired Brenda Davis, Esquire, to represent him. Once Brown signed the attorney-client fee contract, in which Brown agreed to pay Davis a contingent fee of 1/3 of whatever Brown wins in a judgment or settlement, Davis entered an appearance and became the attorney of record. 14-2C. Choosing a court to file a complaint. What to consider. The attorney explained that a number of factors had to be considered before deciding on the forum in which to sue Miller and Clay's estate. What that meant for Brown is that he might be able to bring the suit in a number of forums or courts. 1. In a state trial court where Brown lives. 2. In a state trial court where Miller lives. 3. In a state trial court where Clay lived and where his estate is now located. 4. In a federal trial court sitting in Brown's state. 5. In a federal trial court sitting in Miller's state. Or 6. In the federal trial court sitting in the state where Clay lived. All of these courts would have subject matter jurisdiction over the dispute, the power to resolve particular types of legal disputes. The reason Brown could sue in a federal court is the existence of diversity of citizenship. However, for this to occur, Brown's damages must exceed $75,000. When Brown initially conferred with Davis about the case, Brown brought in all the medical bills, which far exceeded the $75,000 minimum threshold to file in federal court. Davis advised Brown to sue in federal court. Recall our discussion of the court systems in Chapter 7. The suit would be brought in the U.S. District Court sitting in Brown's own state because this would be the most convenient place or venue for Brown. Oftentimes, proper venue could be in multiple courts, and thus may be a strategic decision of the attorney. Consequently, in most judicial systems, there is more than one trial court. For example, there may be one for each county or district. The selection of a particular trial court within a judicial system is referred to as a choice of venue. As suggested by Brown's attorney, there were multiple places to file the lawsuit, and it was determined that the place for filing was in the district court in Brown's own state. Analyze this. What is the distinction between subject matter jurisdiction and personal jurisdiction, and why is this important in the litigation process? 14-2. Initiating the lawsuit. What the plaintiff must do. Having decided on a court, Davis was ready to begin the lawsuit. She instructed her paralegal, Ted Alexander, to prepare the first draft of the document, which is the formal document that sets forth the cause or causes of action against a defendant or defendants. Some states, like Texas, call their complaints petitions. Regardless of the name, this document begins the litigation process. Here, Brown is named as the plaintiff, which is the party who is bringing the lawsuit and is considered the injured or wronged party. Within the complaint, a cause of action was stated for negligence against Miller and Clay's estate as co-defendants, the parties who allegedly committed the injury or wrong against the plaintiff, Mr. Brown. The complaint was the first pleading court document of the case. It starts the lawsuit and gives notice to the defendants of the claims alleged against them. In the complaint, Davis stated the facts she believed constituted a cause of action for negligence. Some of the factual allegations were based on Brown's personal knowledge, while others were based on information and belief. As we will see later in the chapter, facts are developed through discovery. Thus, at the initial stage of filing a complaint, many facts are based on a good faith belief of the truth of those facts. Often not until the commencement and completion of discovery do these facts become provable in a court of law. Known as the discovery process, we will see how the use of discovery techniques assists in developing the facts of a case. An important aspect of the complaint is the prayer for relief in the complaint. This is where the plaintiff tells the defendant or defendants what is claimed. An important aspect of the complaint is the prayer for relief in the complaint. This is where the plaintiff tells the defendants or defendant what is claimed or wanted in damages. In our complaint, Ted, our paralegal, included an ad demonum clause that asked for $100,000 in damages. When Davis finished drafting the complaint, she signed it. The signature, called a subscription of the attorney, is sufficient for this pleading. By the attorney placing her signature on the complaint, she is attesting to the fact that the facts have been investigated and has a good faith belief that Mr. Brown's allegations have legal merit. Note that in this case, the signature subscription of a party, Brown, is not needed. If it was needed, it would be called a verification. The question that the attorney needed to decide
was whether to have a jury trial, which is where a group of people resolve the issues or questions of fact, or a bench trial, where the judge decides both the issues of fact and questions of law. Brown's attorney decided that this was not to be a bench trial, and Davis included a written demand for a jury trial and instructed the paralegal to file the complaint and a civil cover sheet with the clerk of the court. A civil cover sheet is required in many jurisdictions when filing a complaint. It is a form filed in court in a civil case that indicates the names and addresses of the parties and their attorneys. It is a form filed in the court in a civil case that indicates the names and addresses of the parties and their attorneys, the kind of action being filed, and other information required by that court. The form is filed with the complaint. When this was done, the clerk docketed the case. This means that the case became an official filing of that court where it was assigned a unique number for that case known as the docket number. Here, the clerk assigns a unique administrative number to the complaint that will now be placed on all documents filed in that case by all parties, regardless of whether they are the plaintiff or defendant. It is the court's tracking number for the case. A docket number also may be known as a case number. Quick tip: the docket number is one of the most important pieces of information on a legal document. It is its legal court identifier and must be included in all filings in a court case. Most courts include in the docket number the year the case was filed, the type of case, such as civil or criminal, its unique administrative number, and the identity of the court in which the case is filed, such as Superior Court, Probate, Family, Supreme Court, or otherwise. Analyze this. Go to one of your state court's websites for its trial courts and determine what information is included in their docket numbers and the format used by that court. Compare the docket number to your state's highest court and note the differences in format. Service of process came next. This is the formal delivery of notice to a defendant that a suit has been initiated, to which a response must be filed. The most common method of service of process is to place the complaint and summons in the hand of the defendant. This is called personal service. If another form of service is allowed, like for example, service by mail, it is called substituted service or constructive service. The rules of court procedure and statutes determine what kind of service of process is proper. Online exercise. Determine in your jurisdiction the proper methods of service of process, both in state and federal courts. Place that information in your portfolio binder. It was accomplished when a copy of the complaint, along with the summons, was served on both Miller and the legal representative of Clay's estate. Miller and the estate had to respond to the summons in order to avoid a default judgment, the entry of a judgment by the court when a party fails to respond to a complaint. Neither Davis nor the paralegal served Miller and the estate. Davis used a process server, someone authorized to serve legal papers, who then had to file with the court a proof of service indicating the circumstances under which service was achieved. Service was made before the statute of limitations on the negligence cause of action had run out. Service was made before the statute of limitations on the negligence cause of action had run out. Filing a complaint before a statute of limitations runs is a critical step in the litigation process. If the time period in which a complaint to be filed is missed, that is the statute of limitations. the lawsuit could be legally prevented from going forward. Think of it this way: no matter how great a case a client has, in most instances, if a statute of limitations is missed, the case will be dismissed, and the plaintiff or party will not be permitted to recover damages. Consider it the death knell for a client's case and a possible malpractice claim for the attorney. See Exhibit 14-1 for a summary of the steps to consider in filing a complaint. Exhibit 14-1, Steps for filing a complaint. Retain attorney. Prepare engagement or retainer agreement. Interview and investigate claims. Gather all documents and information to support claims or causes of action. Attorney determines which court to file, federal, state. Prepare complaint. Draft complaint with allegations, causes of action, and relief sought. File complaint with court. Prepare summons and civil cover sheet. Docket number assigned. Quick tip. One of the most important questions that will be asked in a client interview is, when did the jury or incident you want relief from occur? From that date, a timeline will be created that must comport to the legal time frame in which that cause of action must be filed. All causes of actions have different time frames, and attorneys and paralegals must be familiar with those time frames before a case is accepted. They are found through legal research in state or federal statutes. What is the time period in which a negligence action must be filed in your state? Research what facts may extend a statute of limitations. Place this information in your portfolio binder. 14-2E. Responding to the lawsuit. What the defendants can do. Now, once the defendants were properly served, the court acquired personal jurisdiction over them. By acquiring personal jurisdiction over a defendant, a court can determine a person's rights. They can issue a judgment against that defendant, award money damages, and make orders against parties when a court has personal jurisdiction over them. All the parties that sent litigation holds to each other. All the parties then sent litigation holds to each other. A litigation hold is a notice to all parties in a lawsuit that a legal dispute has occurred and that information pertinent to the dispute must be preserved by the person or organization in possession or custody of such information. The failure to do this may result in sanctions against the parties. One reason sanctions may be ordered by a court in a litigation case is for spoliation of evidence. This is the intentional destruction, concealment, or alteration by a party of evidence in a case. This issue becomes particularly critical in the area of discovery where claims of spoliation are made, and worst yet proven. To have an understanding of the importance of preserving evidence in a case and the resulting consequences, we look to Lamb v. Outback Steakhouse of FLA LLC, 2021, U.S. District, Lexus 189772, asterisk, 2021, WL 4507521. Quick tip. The correct word for the destruction or alteration of evidence is spoliation. It is not spoliation. The correct word for the destruction or alteration of evidence is spoliation. It is not spoliation. That is the act of stripping something or taking something by force. Order of the court, a case study. Lamb v. Outback Steakhouse of Florida, LLC, U.S. District Court for the Middle District of Georgia, 2021, U.S. District, Lexus 189772, asterisk, 2021 WL 4507521. Lamb vs. Outback Steakhouse involves an incident where Jean Lamb slipped and fell in the lobby area of an Outback Steakhouse. Outback has a detailed incident reporting procedure. Various managers are informed of an incident where reports are made to the Outback Legal and Claims Department. On February 21st, 2029, Miss Lamb fell, her leg swelled, and was in pain. An ambulance was requested for Lamb, and she was transported to a hospital. Surgery was required on her leg, necessitating an 8-day hospital stay. After her hospital stay, Lamb went through 21 days of rehabilitation at another facility. There was surveillance video of the incident as well as documentation from Outback employees on the incident. On April 9th, 2019, Lamb's attorney sent a spoliation letter to Outback demanding preservation of certain pieces of information, including videos of Lamb, videos of the interior of the restaurant on the day of the incident, and incident reports about the accident. Months later, on November 8, 2019, discovery was served on defendants, which included requests for videos and incident reports. Outback was not forthcoming in its responses, causing delays and court intervention. Because of Outback's lack of response in discovery and its failure to produce requested documents, Lamb filed motions for sanctions. The basis of the motion was concealment of documents and spoliation of evidence. Lamb contended that Outback destroyed surveillance evidence and inspection reports regarding the condition of the floors at the time of the incident, as well as reports from the days leading up to the incident. Lamb further contends that emails to managers were concealed and only produced when the court intervened. Outback responded to requested information such as checklists were not relevant and that failure to preserve the videos of the incident were not intentional. The court analyzed the factors to consider in a spoliation claim. They are: 1. The missing evidence existed at one time. 2. The spoliating party had a duty to preserve the evidence. And 3. The evidence was crucial, not just relevant, to the moving party's ability to prove her case. ID at *17. Once the court makes that determination, then it analyzes whether sanctions are proper. It must consider whether the moving party was prejudiced, whether the prejudice can be cured, whether the evidence was important, whether the spoliating party was acting in bad faith, and whether there was potential for abuse regarding expert testimony. Here, the court determined whether the requested discovery information was crucial to the case and whether the loss of logs and checklists amounted to spoliation. Lamb's attorney did not show that the documents requested were crucial to the case and that deposition testimony did not produce the needed information for the case. Regarding the video spoliation, Outback admits spoliation of the videos. In that regard, the court found the bad faith in its failure to preserve the videos of the incident. As part of its analysis, the court focused on the fact that Outback could not explain what had happened to the videos and why they had been destroyed, even though they knew about the need to preserve the evidence. The sanctions that were ordered by the court was that the jury will be instructed to presume that the surveillance lost to spoliation was relevant and favorable to the plaintiff and unfavorable to Outback, but Outback can rebut this presumption with its own evidence. ID at *27. Regarding its failure to properly respond to the interrogatory requests, even after court intervention, the court found Outback's conduct as sanctionable and ordered it to pay 1/2 of Lamb's attorney fees in bringing the motion for sanctions. Ultimately, the court ordered sanctions for some of Outback's conduct relating to its unresponsiveness to discovery and its failure to preserve evidence as required by the discovery rules. Discussion questions. Read Lamb vs. Outback Steakhouse. Why did the court not find for the plaintiff? Why did the court not find for the plaintiff regarding the spoliation of the checklists and manager's logs? What court and case did the court rely upon in finding bad faith and sanctioning Outback for spoliation of the video? Why did the court find Outback's conduct sanctionable under Rule 26? Were the court's actions proper in Lamb vs. Outback Steakhouse? Defend your response. Both Miller and Clay's estate filed motions to dismiss for failure to state a cause of action. Both the federal and state courts have rules for filing motions to dismiss. These are known as the procedural rules, which govern the mechanics of resolving a dispute in court. The Federal Rules of Civil Procedure, Rule 12, identifies the various kinds of motions and defenses that can be filed to dismiss a complaint or a claim. Rule 12b states, B. How to present defenses. Every defense to a claim for relief in any pleading must be asserted in the responsive pleading if one is required, but a party may assert the following defenses by motion. 1. Lack of subject matter jurisdiction. 2. Lack of personal jurisdiction. 3. Improper venue. 4. Insufficient process. 5. Insufficient service of process. 6. Failure to state a claim upon which relief can be granted. And 7. Failure to join a party under Rule 19. A motion asserting any of these defenses must be made before pleading. If a responsive pleading is allowed, if a pleading sets out a claim for relief that does not require a responsive pleading, an opposing party may assert at trial any defense to that claim. No defense or objection is waived by joining it with one or more other defenses or objections in a responsive pleading or in a motion. One of the most common motions to dismiss is what is commonly known as Rule 12b6 motion, failure to state a claim upon which relief can be granted. What a 12bb generally states is that a party has failed to allege enough facts that, if proved, would entitle the party to judicial relief. Even if the party proved every fact alleged, the facts would not establish a cause of action entitling the party to recover against the opponent. The motion to dismiss for failure to state a cause of action is sometimes referred to as a demurrer. Some state courts, such as California, or B. A failure to state a claim upon which relief can be granted in federal courts and many state courts. A failure to state a claim upon which relief can be granted in federal courts and many state courts. In our Brown case, the court issued a ruling that denied both motions. Because the case had been filed in a federal court, the procedural law governing the case would be found in the Federal Rules of Civil Procedure, which are the rules followed in a dispute in a U.S. District Court, which is the main federal trial court. The substantive law of the case would be the state law of negligence. According to the Federal Rules of Civil Procedure, Miller and Clay's estate were each required to file an answer to Brown's complaint within 20 days. The answer is the first pleading of the defendant in response to the plaintiff's claims. Miller filed his answer almost immediately because Clay was dead and unable to tell his attorney what happened at the accident. The attorney for the estate had some difficulty preparing an answer and was unable to file it within 20 days. To avoid a default judgment against the estate, the attorney filed a motion asking for an extension of 30 days within which to file the answer. The motion was granted by the court and the answer was filed within the new deadline. Analyze this. What is the distinction between procedural and substantive rules in a court? Why is this an important distinction? The answers contained the parties' defenses. A defense is an allegation of fact or a legal theory offered to offset or defeat a claim or demand. It suggests why the plaintiff should either not recover or not recover in the amount suggested by the plaintiff. The answer filed on behalf of Clay's estate denied all allegations of negligence and raised an affirmative defense of contributory negligence against Brown on the theory that if Clay had been partially responsible for the collision, it was because Brown had carelessly been distracted by the conversation in the car. An affirmative defense raising facts or arguments that will defeat the opponent's claim, even if the opponent's allegations in the claim were proven. Many jurisdictions list the affirmative defenses in their procedural rules and statutes. It is important to note that many affirmative defenses must be raised at the time an answer is filed, or they may be waived, or the opportunity to raise them completely lost. It is incumbent on the attorney and paralegal to know what affirmative defenses must be raised in an answer at the beginning of a lawsuit. And finally, the answer of Clay's estate raised a cross-claim against the co-defendant Miller, alleging that the accident had been caused by Miller's negligence. A cross-claim is a claim brought by one defendant against another defendant or by one plaintiff against another plaintiff. In the same action. A cross-claim is a claim brought by one defendant against another defendant or by one plaintiff against another plaintiff in the same action. In addition to a cross-claim, there can be counterclaims. This is where a defendant files a claim against the plaintiff. Think of cross-claims and counterclaims as lawsuits within a lawsuit. Here, the estate asked $1 million in damages. See Exhibit 14-2 for a diagram of a cross and counterclaim within a lawsuit. Exhibit 14-2, diagram of counterclaim and cross-claim. Plaintiff versus defendant, counterclaim, lawsuit filed by the defendant against the plaintiff in response to the original filing of the complaint. Plaintiff versus defendant, cross-claim, lawsuit filed by a co-party against another co-party, defendant versus defendant. Miller's answers also raised the defense of contributory negligence against Brown and stated a counterclaim against Clay's estate, alleging that the accident had been caused solely by the negligence of Clay, or of Clay and Brown together. On this same theory, that Brown together with Clay had negligently caused the accident, Miller's answer also stated a counterclaim against Brown, to which Brown immediately filed a reply or answer. Miller sought $50,000 from Brown and $50,000 against Clay's estate as damages. For a time, Miller and his attorney considered filing a third-party complaint against Miller's own automobile insurance company, because the company would be liable for any judgment against him. A third-party complaint is a defendant's complaint against someone who is not now a party to the lawsuit on the basis that the latter may be liable for all or part of what the plaintiff might recover from the defendant. They decided against this strategy because they did not want to let the jury know that Miller was insured. If the jury knew this fact, it might be more inclined to reach a verdict in favor of the plaintiff and for a high amount of damages. The strategy was also unnecessary because there was no indication that Miller's insurer would contest its obligation to compensate Miller within the policy limits of the insurance for any damages that he might have to pay Brown or Clay's estate in the event that the trial resulted in an adverse judgment against him. At this point, 5 claims had been filed by the parties. A 6th, Miller's third-party claim, against the insurer had been considered but ultimately had not been filed. These claims and their relationship to each other are illustrated in Exhibit 14-3. Exhibit 14-3, claims in the Brown-Miller-Clays estate litigation. Defendant Miller, third-party defendant insurance company, plaintiff Brown, defendant Clays estate. 1. Plaintiff Brown's complaint seeking $100,000 for negligence against Miller. 2. Plaintiff Brown's complaint seeking $100,000 for negligence against Clay's estate. Miller and the estate are co-defendants. 3. Defendant Miller's counterclaim seeking $50,000 for negligence against Plaintiff Brown. 4. Defendant Miller's cross-claim seeking $50,000 for negligence against the co-defendant Clay's estate. 5. Defendant estate's cross-claim seeking $1 million for negligence against its co-defendant Miller. 6. Third-party complaint that defendant Miller considered but ultimately decided not to file against the insurance company. One, Plaintiff Brown's complaint seeking $100,000 for negligence against Miller. 2. Plaintiff Brown's complaint seeking $100,000 for negligence against Clay's estate. Miller and the estate are co-defendants. 3. Defendant Miller's counterclaim seeking $50,000 for negligence against Plaintiff Brown. 4. Defendant Miller's cross-claim seeking $50,000 for negligence against the co-defendant Clay's estate. 5. Defendant estate's cross-claim seeking $1 million for negligence against its co-defendant Miller. 6. Third-party complaint that defendant Miller considered but ultimately decided not to file against the insurance company. Once the pleadings were filed, the first pretrial conference was held before a magistrate. Recall from Chapter 7 that a magistrate judge is a judicial officer with some but not all the powers of a judge. In federal trial courts, U.S. District Courts, the magistrate may conduct many of the preliminary or pretrial proceedings in both civil and criminal cases. The main purpose of the conference was to go over any anticipated concerns about discovery. The next stage in the proceedings, the magistrate also obtained an overview of the case from the parties and made inquiries about the possibility of settling the dispute without a trial. Neither side, however, was interested in settlement, so discovery began to Neither side, however, was interested in settlement, so discovery began after the magistrate issued a scheduling order. (14-2F) The discovery process. Since the parties were not interested in settlement, discovery would commence. Discovery is the method used by parties to learn more about a case. The parameters and rules for discovery are generally found in the Rules of Civil Procedure and the state equivalent rules. In the federal rules, the general discovery rule is found in Rule 26, which sets the parameters for discovery in a civil action. Gaining access to an opponent's information is not always easy, but that information gained from each other before trial is used to aid in trial preparation and helps to narrow the issues and learn more about the facts and available evidence. Examples of methods of discovery include requests for admissions, interrogatories, production of documents, physical or mental examination, and depositions. Each method of discovery was discussed in Chapter 13. In the Brown case,
each attorney first served interrogatories, questions on the opposing parties. These were followed by depositions and requests for admissions. Although more costly, depositions are a typical form of discovery as questions can be asked directly to a witness in real time. Recall from Chapter 13 that a deposition is a method of discovery by which parties and their prospective witnesses are questioned by the opposing party before trial at a location other than the courtroom. Judges are not present during depositions, only the parties. The person who is questioned, deposed, is called the deponent. A recording or transcript, a word-for-word account, is made of the deposition. It is a word-for-word account of what was said, a written copy of what was said. After the deposition concludes, the court reporter, who is the person who takes down and transcribes the deposition proceeding, prepares this transcription, which is paid for by the parties requesting it, for his deposition. Miller was also served with a subpoena ducis tecum, which ordered him to bring his driver's license and car registration to the attorney's office, where the deposition took place. A deposition with a subpoena ducis tecum is common. It simply adds a production of documents that the deponent needs to bring to the deposition. This is often a faster way to gain access to documents than through a request for production of documents. Mr. Miller compiled with this order to produce the documents at this deposition. As mentioned, an alternative way in which Miller could have obtained copies of these records would have been to file a request for production, RFP, during the deposition. Miller refused to answer several questions. As a result, Brown's attorney had to file a discovery motion in court, seeking an order compelling Miller to answer. A court hearing was subsequently held on the motion, which was a means to resolve the disputes between the parties. All parties were present at the hearing before the judge, who was an impartial officer. It is important to note that on rare occasions, usually when an emergency exists, a hearing may be conducted ex parte, where only one party is present. This is the exception to the rule, as almost all hearings have both parties present in what is considered an adversary. This is the exception to the rule, as almost all hearings have both parties present in what is considered an adversarial setting, where all parties are permitted to present evidence, argument, and information to the judge. Hearings are not limited to the civil litigation context. They occur in criminal as well as in administrative agencies. After listening to arguments by all of the attorneys, the judge granted the motion in full, ordering Miller to answer the questions. Faced with the court's order, Miller answered the remaining questions. Each party then filed a motion for summary judgment. A motion for summary judgment is a method of ending the lawsuit. To be granted a summary judgment, the court must find that there are no material issues of fact and that the moving party is entitled to judgment as a matter of law. Attached to the motion is normally discovery evidence of non-disputed facts that shows why the moving party is entitled to summary judgment. Often, the non-disputed facts are established in affidavits, which are part of the summary judgment evidence, which is a summary judgment. With a summary judgment, there is no full trial because of the absence of dispute on any of the material facts. Summary judgment can be granted on the entire case or an individual. Summary judgment can be granted on the entire case or on individual claims or defenses within the case, and thus a partial summary judgment. In the Brown case, the judge considered all the arguments and evidence presented and denied these motions. The case now is ready for trial. See Exhibit 14-4 for a diagram of the forms of discovery. Exhibit 14-4, Methods of Discovery in a Civil Case. Depositions, oral or written questions, interrogatories, requests for admissions, production of documents, request for physical and mental examination, request for permission to enter upon land. These are discovery methods. (14-2G), Getting ready for trial. What happens? As the trial neared, each of the attorneys received a notice asking them to appear before the magistrate for another pretrial conference. During the conference, the magistrate, with input from the attorneys, prepared a pretrial statement for the trial judge on the case. It contained a statement of the facts that had been stipulated by the attorneys and the facts that were still at issue. Questions of law are issues that are resolved by a judge, whereas questions of fact are resolved by a jury. The exception is with a bench trial, where the judge resolves both legal and factual issues. It also listed the tangible evidence, physical evidence, and witnesses that each party intended to introduce at the trial, as will be discussed later in the chapter. Preparation also includes creating a trial notebook, which is a guide for both the attorney and paralegal, such as legal research on issues, discovery, pleadings, and any other necessary information needed at trial. Additionally, pretrial motions are made to the court as well. A typical pretrial motion is a motion in limine, which limits certain evidence from being presented during the trial. Brown's attorney made a motion. She wanted to prevent the other attorneys from introducing into evidence any reference to a case 5 years ago when Brown was sued for negligently causing a brush fire in his neighborhood. The judge granted the motion. These motions can be made before trial or at the trial, depending on the circumstances, but they are normally best made before the trial starts, so there are no evidentiary surprises that could result in issues on appeal. 14-2H, the trial, understanding the process. After some delay, the case was finally set for trial, with all of the parties and their attorneys assembled in the courtroom. After some delay, the case was finally set for trial, with all of the parties and their attorneys assembled in the courtroom. The judge entered, took the bench, and ordered the bailiff to summon a jury panel for trial. A jury panel is the group of citizens who have been called to jury duty. From this group, juries for particular trials are selected. Another term for jury panel is venue or jury pool, as will be discussed later in the chapter. Attorneys and paralegals rigorously study the jury pool to determine which jurors will be the best suited to hear their case. Attorneys are looking for jurors who appear to be able to be neutral, listen to the facts, and render a decision hopefully in that party's favor. Once the potential prospective jurors were seated in the courtroom, voir dire began. Voir dire is just a fancy way to say asking questions for prospective jurors to determine if they are suited to sit on the case and render a decision. Several jurors were challenged for cause and dismissed. One because she has worked for the insurance company that had issued the policy on Miller's car. What this means is that one of the attorneys on the case requested directly to the judge that a prospective judge not serve on the case for specified causes or reasons. In this instance, it was more than likely that Brown's attorney challenged the juror for cause. It most likely was the position as to this prospective juror that they have or might have a bias, an inclination, predisposition, or even prejudice to think or act in a certain way. Attorneys are always on alert to predetermine potential bias in a prospective juror.
Is she in our office?
Mhm.
Is someone still in there?
Yeah.
Okay.
Several other jurors were dismissed as a result of peremptory challenges. A peremptory challenge is a request from a party to a judge asking that a prospective juror not be allowed to become a member of this jury without stating a reason for this request. Each side is allowed a limited number of such challenges. The request will be granted unless it is used to discriminate on the basis of race, sex, or ethnicity. 12 jurors plus 2 alternatives. 12 jurors plus 2 alternates were eventually impaneled. The formal selection and swearing in on the jury. They then were seated in the jury box. Social media, juror information, and what is permissible. Before a trial begins, the parties receive general information about the prospective jurors. When that happens, the parties want to find out as much information about the prospective jurors as possible. One place that is a treasure trove of information are social media sites. The question is whether there are limitations on legal professionals as to how they acquire information, and the answer to that question is yes. As part of a legal professional's due diligence in researching potential jurors, social media sites and even Google can be used and should be, but the legal professional cannot be deceitful in gaining access to social media accounts, such as setting up a fake account or friending a juror to get access to their accounts to gather information. This is improper, and many bar associations have warned attorneys against using these methods. Legal professionals cannot communicate with potential jurors and must maintain that ethical distance. What is available to the legal professional is the public information posted on social media. There you may learn about a prospective juror's views and learnings, as well as general background information that may not be revealed during voir dire. Imagine a high-profile case that you are working on in your city, and a prospective juror posted comments about their opinions on the matter. This is something that the litigation team would want to know, and finding the information legitimately can be critical in vetting a juror's suitability to sit on a case. There are cases where courts have sanctioned prospective jurors for not being honest when responding to questions about their views or knowledge about a case, and especially when the legal team finds information to the contrary on social media. Thus, using social media and doing the background research is critical, but it must be done within the bounds of professional ethics. Legal professionals cannot misrepresent their identities in order to gain access to a potential juror's social media accounts. An example was cited in a New York City Bar Association opinion when it stated that a person could not claim to be an alumnus of a school when in fact they were not. To gain access to a webpage strictly limited to people from that school, see NY City Bar Association on Professional Ethics, Formal OP 2012-2-2012. For legal professionals, this means that viewing social media accounts of prospective jurors is part of the due diligence process, but must be done in such a way that does not invade jurors' privacy rights, but reveals essential information during the voir dire process. That means that a legal professional can review a potential juror's social and online presence, but cannot communicate directly or indirectly with a potential juror or use another person to attempt to access a social media account. But what happens if you discover information about the potential juror that shows that the person was deceitful, untruthful, or had criminal or fraudulent misconduct that was not reported on the juror information questionnaire? The information must be reported by the attorney to the court so a determination can be made as to how that affects that person's suitability as a juror. Consequently, social media review of potential jurors is part of the due diligence process, but must be done in an ethical manner. Online exercise. Research your jurisdiction's number of peremptory challenges permitted for a jury trial in a civil case in state and federal court. Are the number of peremptory challenges the same or different? When the juror was seated, Brown's attorney told the judge that she wanted to invoke the rule on witnesses. This requires certain witnesses to be removed from the court until it is time for their individual testimony, so that they would not be able to hear each other's testimony. Some attorneys in some states will simply ask the court to invoke the rule. It is the same as invoking the rule on witnesses. You also may hear an attorney ask the court to sequester the witnesses. Again, all these terms mean the same thing. In the Brown case, the judge agreed to sequester them. The bailiff led all of the witnesses except for the parties themselves out of the courtroom. Brown's attorney then began the trial with her opening statement or opening argument to the jury. This is an attorney's statement to the jury or to the judge alone in a bench trial where there is no jury, made before presenting evidence. The statement summarizes or previews the case the attorney intends to try to establish during the trial. Unrepresented parties make the statements themselves. When she finished, Miller's attorney also delivered an opening statement. The attorney for Clay's estate, however, decided to reserve his opening statement until it was time to present the estate's case. Quick tip: an opening argument or statement by an attorney in a trial is not evidence that can be considered in deciding the case. An opening argument or statement by an attorney in a trial is not evidence that can be considered in deciding the case. It is an argument and is the attorney's opportunity to preview their case in a positive light to the judge or jury. In this case, Brown has the burden of proof to show that the other parties were responsible for his injuries. The burden of proof is a critical evidentiary standard as a case rises and falls on establishing that burden. Thus, the burden of proof is the responsibility of the party making the factual allegation to show through evidence that a fact is proven at trial. A discussion between the judge and attorneys held at the judge's bench so that the jury cannot hear what is being said. When the attorney had gathered around the bench, the attorney stated that he had an objection to the witness on the basis that the witness was not competent to testify. What this refers to is the legal ability of someone to testify, either at trial, a hearing, or even a deposition. For example, everyone must have the legal capacity to give testimony, meaning that the person understands the obligation to tell the truth, has the ability to communicate, and has knowledge of the topic of their testimony. The judge then excused the jury temporarily while he conducted a brief examination of the witness. The judge overruled the objection upon being satisfied.
that the boy was mature enough to understand the obligation to tell the truth, had the ability to communicate, and had knowledge of the topic about which the attorney wanted to question them. The jury was brought back into the courtroom, and Brown's attorney began the direct examination of the witness. In direct examination, the party who called the witness begins asking questions. These questions cannot be leading questions which suggest the answers in them. Questions on direct examination will be open-ended questions which usually call for a narrative response. After a few questions, Miller's attorney again objected, this time on the ground that if the child was allowed to answer the question, "What did your father tell you about the accident?" the answer would be hearsay, meaning that the child was testifying about something that someone else said to him. See Chapter 13 on hearsay. The judge sustained the objection and agreed that the question was not permissible. Brown's attorney continued the examination of the witness for a few minutes before announcing that she had no further questions. The attorney for the estate then rose to conduct a brief cross-examination of the boy. In cross-examination, the opponent is permitted to question the witness from the other side after the direct examination is complete. Generally, the person conducting the cross-examination must limit their questions to the topics or subject matters raised during the direct examination of this witness. Generally, the person conducting the cross-examination must limit their questions to the topics or subject matters raised during the direct examination of this witness by the other side. He was followed by Miller's attorney, whose cross-examination was also brief. There was no redirect examination and therefore no recross-examination. Brown's attorney, Davis, called several other witnesses who had seen the accident. Each witness was examined and cross-examined in much the same fashion as the boy had been. Davis was about to call the fourth witness, Dr. Hadley, when the judge announced a recess for lunch. The judge admonished the jury not to discuss the case with anyone, even among themselves, and ordered everyone to be back in the courtroom by 2 p.m. Dr. Hadley was called to the stand immediately after the lunch recess. Brown's attorney began a direct examination with a series of questions about the doctor's medical training and experience in order to qualify him as an expert witness. This means that Brown's attorney had to ask Dr. Hadley some preliminary questions to show evidence of the doctor's education, technical knowledge, specialization, and experience sufficient to convince the court that the requisite expertise in the particular area is present in which testimony is to be given. See Exhibit 14-5. She then moved that Dr. Hadley be recognized as an expert witness. The court, with no objections by either defense counsel, granted the motion. Exhibit 14-5, examination of a witness. Attorney Davis conducts a direct examination of Dr. Hadley, the doctor who treated plaintiff Michael Brown. Photo courtesy of James L. Schaffer. Brown's attorney then asked the doctor to testify as to the nature and extent of the injuries that the plaintiff Brown had suffered as a result of the accident. In addition to multiple cuts and bruises, the doctor stated that Brown had suffered a broken knee. The knee, in the doctor's opinion, had been permanently injured, and Brown would continue to suffer periodic pain and stiffness due to the injury. To show the expense of these injuries, someone's in there though. To show the expense of these injuries, the attorney produced the original copies of the bills that the doctor sent to Brown. The attorney handed the bills to the clerk sitting in the courtroom, who marked them as plaintiff's Exhibit number 1. After allowing defense counsel to inspect the bills, Brown's attorney handed them to the doctor.
Your 140's here, ma'am.
Javon.
You want me to go first?
Yeah, she called you.
After allowing defense counsel to inspect the bills, Brown's attorney handed them to the doctor, who promptly identified them. The attorney then moved the bills into evidence and turned the witness over to defense counsel for cross-examinations. Moving information into evidence is an important part of the trial process. This is a direct request to the court to have an item formally declared admissible evidence in a case. Each piece of evidence that is admitted builds on the party's case, establishes the all-important burden of proof. So let's add an evidentiary crinkle from our additional introductory chapter facts about Clay's past drug use and hospitalizations. Recall Clay died from the accident. Mr. Brown had information about Clay's prior drug use and near overdose. The question is whether that information would be relevant and admissible in this case, or would the evidence be considered inadmissible because its potential prejudice outweighs its relevance. For example, this would be a point that Brown's attorney would have to argue if she deemed it important enough to the civil case. The judge would have to weigh the legal arguments to determine whether the medical records would be admissible. It was late in the afternoon when Brown's attorney finished with the final witness, Brown himself. The judge did not want to recess for the day, however, until the attorneys for the defendants completed their cross-examination of Brown. After about an hour, all the defense attorneys completed their questioning of Brown, and Brown's attorney finished the case. The attorney had concluded her case in chief, the main presentation of the case and evidence. The judge adjourned the trial until the following morning. On the following morning, the attorney for Clay's estate advised the judge that he had a preliminary matter to bring up before the jury was brought into the courtroom. He then proceeded to make a motion for a judgment as a matter of law in favor of the estate on Brown's claim of negligence. This type of motion usually occurs at the end of the presentation of the plaintiff's case in chief. A judgment as a matter of law may be rendered before or after the verdict. In federal courts and in some state courts, this judgment is called a directed verdict if it is rendered before the jury reaches a verdict, and is called a judgment notwithstanding the verdict, JNOV. If it is rendered after the jury reaches a verdict, the judge listened to arguments by the attorneys on the motion. The judge decided that he would neither deny nor grant the motion, but would take it under advisement. The judge decided that he would neither deny nor grant the motion, but would take it under advisement. Miller's attorney also moved for a judgment as a matter of law on the negligence claim of Clay's estate against Miller. After hearing the arguments on this motion, the judge denied it because Clay's estate had introduced sufficient evidence to make out a prima facie case of Miller's negligence. To make a prima facie case, a party must present sufficient evidence that will prevail unless the other side presents more convincing counter-evidence. Hence, the court allowed this claim of negligence to go to the jury for their determination. The jury was summoned into the courtroom and seated in the jury box for the second day of the trial. The attorney for the estate began his case by making an open statement to the jury. Reversed from the previous day, he then proceeded to call the witnesses. He had only 2 witnesses and was able to conclude the case just before noon, at which time he introduced Clay's death certificate into evidence. The judge then declared a recess for lunch. Miller's attorney began to present his case in the afternoon, and by late afternoon, they too had rested his case. The judge dismissed the jury until the following morning and told the attorneys to be prepared for closing arguments or closing statements at that time. Closing arguments or statements are the final statement by an attorney to the jury or to the judge alone in a bench trial where there is no jury. The statement summarizes the evidence that was presented during the trial and requests a favorable decision. Unrepresented parties make the argument themselves, like opening statements. A closing statement is not evidence that a jury or judge can consider in rendering a decision on the case. The judge also asked the attorneys to submit any jury instructions they would like to request so that he could review them. Jury instructions are an important component of a trial. They are a statement of the law given to the jury by the judge for use in deciding the issues of fact in its verdict. The instructions to the jury are also referred to as the charge to the jury. The attorneys are allowed to submit proposed instructions for consideration by the judge. Brown's attorney requested an instruction that the co-defendants had to overcome a presumption of negligence against them. The judge denied this request. Finally, the judge announced that he had decided to deny the estate's earlier motion for a judgment as a matter of law. Quick tip: most jurisdictions have standard jury instructions that can be found online from a fee-based service such as Westlaw or LexisNexis, or in specialized online or print editions. Always check your specific jurisdiction for their jury instructions. They may be referred to as pattern jury instructions. Analyze this. Determine how your state courts prepare and draft jury instructions. Are there standard jury instructions for cases in your state? Does your state have standard jury instructions for a negligence case, and if so, what are those instructions? In the closing arguments, each attorney carefully reviewed the evidence for the jury and argued for a verdict decision in favor of their client. Following a brief recess for lunch, the judge began to instruct the jurors on the law they were to follow in finding the facts and in reaching a verdict. The judge said that they, as jurors, were the finders of fact and were to base their decisions solely upon the testimony and exhibits introduced during the trial. The judge explained the concept of burden of proof and stated which party had to carry this burden as to each of the various elements of negligence. Each element had to be proved by a preponderance of evidence, which means that the evidence establishes that it is more likely than not that the facts are as alleged. This was the standard of proof for this kind of case. There are two standards of proof in civil cases: preponderance of evidence and clear and convincing. Finally, the court described the manner in which they should compute the amount of damages, if any, suffered by the parties. The jury was then led out the courtroom to deliberate on its verdict and thus make a decision. The judge retired to his chambers, and the attorneys settled back with their clients to wait. About an hour, the judge received a note from the foreman of the surgery. After about an hour, the judge received a note from the foreman about the jury, asking that the jury be allowed to view several of the exhibits. The items requested were the medical bills allegedly incurred by Brown and Clay. The attorneys for Brown and for the estate took this as a good sign. The jury had probably decided the case against Miller and was now trying to compute damages. A second note arrived in another hour, announcing that the jury had reached a verdict. The bailiff summoned everyone back to the courtroom, and the jury came in a few minutes. Later. At the clerk's request, the foreman rose to read the verdict. 1. On Brown's complaint seeking $100,000 for negligence against Miller, the jury found for Brown, awarding Brown $30,000 in damages. 2. On Brown's complaint seeking $100,000 for negligence against Clay's estate, the jury found for the estate. 3. On Miller's counterclaim seeking $50,000 for negligence against Brown, the jury found for Brown. 4. On Miller's cross-claim seeking $50,000 for negligence against the estate, the jury found for the estate. 5. On the estate's cross-claim seeking $1 million for negligence against Miller,
The jury found for the estate, awarding the estate $750,000 in damages. The judge entered a judgment decision against Miller in the amounts awarded by the jury. After denying a motion by Miller for a judgment as a matter of law, the judge thanked the jurors for their service in the case and dismissed them. As an aside, there are other kinds of civil actions where other types of judgments are entered by the court. For example, when parties want to establish rights and obligations of the parties, or to have a party refrain from doing something, a judge may enter a declaratory judgment. For example, when parties want to establish rights and obligations of the parties, or to have a party refrain from doing something, a judge may enter a declaratory judgment. In our case, suppose that the insurance company had denied coverage for Brown's injuries and believes that the denial was wrongful or unjust. Brown wants to sue for their losses. Brown could seek a declaratory judgment asking the court to determine the rights and obligations of the parties under the insurance policy. A declaratory judgment could be used to acknowledge the validity of the insurance policy. For example, if the insurance company takes the position that the policy is invalid because of non-payment, declaratory judgment actions are used in a myriad of cases. 14-2I, post-trial procedure. What can a losing party do? Motions and appeals. Miller's attorney immediately made a motion for a new trial, arguing several possible grounds. A motion for a new trial is a request to a judge to set aside the judgment and order a new trial because the evidence is insufficient to support the judgment. A new trial also can be granted on the basis of newly discovered evidence or because of errors committed during the trial. Overcoming the standards of proof for a motion for new trial are difficult and not often granted. When this motion was denied by the trial judge, the attorney moved for a reduction of the verdict on the grounds that the amounts awarded were excessive. This motion was also denied, and the attorney announced their intention to seek an appeal. The judge granted Miller a stay of the judgments, conditioned upon a filing. The judge granted Miller a stay of the judgment, conditioned upon a filing a timely notice of appeal and arranging for the appropriate bond. A stay permits the status quo to continue. If granted, this means that, in this case, Miller would not have to pay any monies until the appeals process was exhausted. The case decision of the court stays on hold until a final determination by the appeals court. See Exhibit 14-6. Exhibit 14-6, Summary of Trial Process. Jury selection, voir dire, opening statement, presentation of plaintiff's case in chief, presentation of evidence, direct cross-examination, redirect, plaintiff rests motion by defendant, defendant's case, presentation of witnesses and evidence, closing arguments by the parties, judge's instructions to the jury, deliberation and verdict. Miller asked his attorney what the $30,000 verdict against them meant. Brown had originally sued for $100,000. Could Brown later sue Miller again for the rest of the amount he claimed? The attorney explained that because of the stay granted by the judge, Miller would not have to pay anything until a decision on appeal had been reached. Furthermore, Brown could not sue Miller again on the same cause of action because Brown had received a judgment on the merits that would be res judicata and would bar any later suit based on the same facts. This means that the judgment precludes Brown from suing Miller on the same issues or for the difference in the amount that the jury did not award. For all intents and purposes, The judgment is final in all respects, and Brown cannot attempt to retry his claims in another court. That is res judicata. Because of this legal concept, Brown would be prevented from pursuing the same claims in this litigation against Miller. This would also be true of a later action by Clay's estate against Miller. Miller's attorney filed a notice of appeal with the U.S. Court of Appeals and posted bond the following week. As representative for this appellant, the party filing the appeal, the attorney had to ensure that the record, including transcripts and copies of exhibits, was transmitted to the Court of Appeals and that the case was docketed by the clerk of that court. Miller's attorney then had 40 days in which to draft and file an appellate brief with the Court of Appeals. The attorney served copies of the brief on the attorneys for the appellees. The parties responding to the appeal, Brown and Clay's estate, who in turn filed their appellate briefs concerning the issues on appeal. Thus, the issues on appeal are those claims of error of law committed by a lower court. The appellate court does not retry the case. No witnesses are called and no testimony is taken by the appellate court. The court examines the record and determines whether errors of law were committed by the lower court. See Exhibit 14-7 for the diagram of the appeals process. Exhibit 14-7, diagram of the appeals process. After entry of judgment, filed notice of appeal, complete transcript order form, parties confer regarding content of joint appendix, appellant files brief and serves on appellee, oral argument before appellate panel of judges, notice of oral argument, appellant files reply brief and serves on appellee, appellee files responsive brief and serves on appellant, opinion of the court filed and sent to the parties, mandate issued if no other motions filed, case ready for collection. Several months passed before the attorneys finally received a notice from the clerk of the Court of Appeals that the appeal had been scheduled for oral arguments before a 3-judge panel of the appellate court. The arguments were heard a few weeks later, 6 months after oral argument. The attorneys received the decision of the court in its written opinion. By a vote of 2-1, one judge dissenting, the court affirmed the judgment against Miller. The only error that the majority found was the admission of certain testimony offered through Brown's expert witness. However, because Miller's attorney had not objected to this testimony at trial, the opinion stated he had waived this defect. In the appellate context, only those issues raised or preserved in the trial court can be raised in the appeals court. If a defect is not preserved, generally that party loses the right or privilege because of an explicit rejection of it by the lower court or because of a failure to claim it at the appropriate time. Here the court is referring to the rule that failure to object during trial is an implied waiver of the right to complain about the alleged error on appeal. That is a waiver. See Chapter 7 for a discussion of the courts and its decisions. Miller, undaunted, petitioned for a rehearing by the court in Bank. The rules of appellate procedure provide for a petition for rehearing from an adverse decision from the court. Many attempt to make the request, but appeals courts rarely grant a petition for rehearing, which is a request for second hearing to have the appeals court reconsider the decision it made after an earlier decision. Less granted are a hearing and bank. ENBANC. This is a petition or request to all the members of that court are asked. This is a petition or request to all the members of that court are asked to reconsider the decision of the 3-member panel of that court. Think about what an en banc hearing requests. It asks for the full court to review Thank you, sir.
No problem.
Good afternoon, man.
How are you?
Think about what an en banc hearing requests. It asks the full court to review a decision of judges of that court stating that the decision was wrong. It asks the full court to review a decision of judges of that court stating that the decision was wrong. For the court to act en banc, it has to be an extremely significant deviation from accepted law, which rarely happens. Online exercise. Locate a copy of Guidus vs. Bureau of Alcohol 66 F.4th1019 Fed CIR 2023 for an example of a case where the court denied an en banc request, ENBANC request. Review the case and note that there are accompanying opinions from some of the judges of the court. Summarize the positions of the judges on their en banc decisions. The petition was denied. Miller then discussed the possibility of further appeal with their attorney. The attorney explained that Miller could, if desired, try to appeal the U.S. Supreme Court. The attorney cautioned Miller, however, that he could not appeal by right in this case, but would be limited to a petition for a writ of certiorari. A petition for a writ of certiorari is a request to the U.S. Supreme Court to review a lower court decision. Such petitions are within the court's discretion to grant and are extremely limited. If the writ is denied, the court refuses to hear the appeal, and in effect, the judgment below stands unchanged. If the writ is granted, the case continues on appeal until a final decision is rendered by the U.S. Supreme Court. The attorney advised Miller that it was extremely unlikely that the Supreme Court would grant the petition and that it probably would not be worth the expense. Miller agreed, and no further appeal was attempted. The Court of Appeals issued its mandate affirming the trial court's judgment. Shortly thereafter, Miller, through the insurance company, satisfied the judgment by paying it. There was no need to ask the sheriff to force compliance of the judgment through execution. To execute on a judgment is an attempt to satisfy the court's order. It is a command or writ to a court officer, such as a sheriff, to seize and sell the property of the losing litigant in order to satisfy the judgment debt. Once execution of a judgment is completed, the civil case is generally over. For an overview of the appeals process, see Exhibit 14-7. 2. Criminal liability. Arrest and beyond. As Brown was leaving the hospital, having recovered from injury, he was met at the door by two police officers. The officers produced a warrant, a document from a judicial officer authorizing an act such as an arrest or seizure of property, and advised Brown that he was under arrest. After Brown was read his rights, he was taken to the police station. Hence, in addition to suing Clay's estate and Miller, Brown was now defending himself in a criminal prosecution proceeding. The criminal charge was drug possession. After the collision of the Clay and Miller vehicles, the police found drugs under the passenger seat where Brown was sitting.
The following morning, Brown was taken before a judge for his initial appearance. The initial appearance is the first criminal court appearance by someone accused of a crime, during which the court informs them of the charges and of their rights, makes a decision on bail, and determines the date of the next court date. The judge advised Brown that he had been charged with a felony, possession of narcotics with intent to distribute, a felony which is any crime punishable by death or by imprisonment for more than 1 year, has different consequences from a misdemeanor, which is a less serious offense and punishable for less than 1 year. Next, the judge then advised Brown of his rights, including his right to be represented by an attorney. Because Brown was unemployed and without adequate funds to pay an attorney, he had not won the judgment against Miller. The judge asked if he would like the court to appoint an attorney to handle the case. Brown said yes and was given assigned counsel to represent him. Criminal defendants have a right to appointed counsel by the U.S. Constitution. Assigned counsel can be a private attorney appointed and paid by the court to represent those who cannot afford attorneys, or counsel can be someone appointed from the public defender's office. In most cases, those who have counsel appointed are indigent. In most cases, those who have counsel appointed are indigent, meaning they do not have sufficient financial resources to pay for an attorney to defend them. The judge, at the attorney's request, then agreed to give Brown a chance to confer with the new attorney before continuing the hearing. When the case was recalled, Brown and his court-appointed attorney again approached the bench and stood before the judge. The attorney formally entered their name as attorney of record for Brown and advised the judge that they were prepared to discuss the matter of bail. Bail is the amount of money or other property deposited with the court as security to ensure that the defendant will reappear at designated times. Failure to appear forfeits the security. In some instances, a judge will release a defendant in a criminal case without posting bond, based solely on a promise of the defendant to appear at all scheduled times. This is known as release on personal recognizance. In our case, Brown's court-appointed attorney proceeded to describe for the judge the details of Brown's background, education, employment record, length of residence in the city, etc. The attorney concluded by asking that Brown be released on personal recognizance rather than having to post a bond. The prosecutor was then given an opportunity to speak. They recommended a high bond, pointing out that the defendant was unemployed and had no close relatives in the area. These facts, coupled with the serious nature of a felony charge, indicated a substantial risk that the defendant might try to flee. The judge nevertheless agreed to release Brown on personal recognizance and set a date for a preliminary hearing. The following week, at the preliminary hearing, the court will determine if there is sufficient facts and evidence or probable cause that exists that the accused has committed a crime. Before the preliminary hearing was held, the parties engaged in discovery. It is important to note that civil discovery and criminal discovery are different. In civil cases, the parties request information to be turned over, whereas in a criminal case, prosecutors have a duty to disclose its evidence, regardless as to whether it was requested or not. Thus, in the Brown criminal matter, the prosecution is required to disclose to Brown any evidence it has collected thus far that indicates guilt or innocence. In a criminal case, defendants do not have to disclose as much evidence as they do during discovery in civil cases. The main reason for this is the Fifth Amendment right of defendants not to incriminate themselves by being forced to answer questions about the alleged crime. At the preliminary hearing, the only witness was the police officer who investigated the accident. The officer testified that when he helped pull Brown out of the car, he noticed a small paper sack sticking out from under the passenger side of the front seat. Several glassine envelopes containing a white powdery substance, the officer said, had spilled out of the sack. The substance, totaling about 1/2 ounce, was tested and proved to be 80% pure heroin. Brown's attorney cross-examined the officer briefly, but little additional information came out. The judge found that there was probable cause to hold the defendant and order the case bound over for grand jury action. The judge continued Brown's release on personal recognizance. Not all cases go to a grand jury. A grand jury is a jury of inquiry and not trial jury that makes the final decision of guilt or innocence in a case. They sit for a designated period of time, often a month, receive accusations in criminal cases, hear the evidence of the prosecutor only, but not the evidence of the suspects, and issue indictments, charges, when satisfied that a trial should be held. Our federal system of government uses indictments to charge in criminal cases. On the other hand, some jurisdictions do not have grand juries and do not charge by indictment. Here, some jurisdictions charge crimes by information, which is similar to an indictment, in that it is the document that charges the defendant with crimes. An information is issued by a prosecutor to charge a defendant with crimes. Shortly after the preliminary hearing, Brown's attorney went to the prosecutor to see if they work out an informal disposition of the charge. The attorney tried to convince the prosecutor to enter a nolle prosequi, not to prosecute, on the charge, explaining that Brown had simply been offered a ride home and was not aware that the heroin was in the car. The prosecutor was unwilling to drop the charge. However, he was willing to nolle the felony charge of possession with intent to distribute if Brown would agree to plead guilty to the lesser offense of simple possession of a dangerous drug, a misdemeanor. The attorney said he would speak to his client about it. The options for defendants to plead in criminal cases is guilty, not guilty, or no contest. A defendant initially will enter a plea of not guilty at the arraignment. As we will see, however, as the evidence is revealed and developed in a case, the defendant has the opportunity to change that plea. As we see in Mr. Brown's case, his attorney spoke with him that same afternoon about the prosecutor's offer of a plea bargain. In a plea bargain, there is an agreement whereby an accused pleads guilty to a lesser included offense, such as a misdemeanor in Mr. Brown's case, or to one of multiple charges in exchange for the prosecution's agreement to support a dismissal of some charges or a lighter sentence. Brown was not interested in the plea agreement. Brown believed he was innocent and was unwilling to plead guilty even to a misdemeanor. Several weeks went by before Brown's attorney was notified that the grand jury had returned an indictment against his client. The next step would be the arraignment on the following Monday. On this date, Brown and his attorney appeared before the judge, and Brown was formally notified of the indictment. Brown entered a plea of not guilty to the charge. The judge set a trial date 10 weeks from that day and again agreed to continue Brown's release on personal recognizance. 14-2K, the trial, the rights of the defendant. The day for the trial arrived. Brown's attorney and the prosecutor announced that they were ready. Voir dire was held and a jury was impaneled. The trial itself was relatively uneventful, lasting less than a day. The prosecutor, following a brief opening statement, presented only 2 witnesses: the police officer who had been at the scene and an expert from the police lab who identified the substance as heroin. The attorney then rested his case. Brown's attorney made his opening statement and presented his only witness, Brown himself. Recall that under the Fifth Amendment to the U.S. Constitution, Mr. Brown has the right to not testify. It is the prosecutor that must prove that the heroin was Mr. Brown's, although in some instances, defendants like Mr. Brown will decide to testify on their own behalf. The jury listened attentively as Brown, on direct examination, explained the events leading up to the accident and his subsequent arrest. Not only had he been unaware of the heroin, Brown testified, but he had never even seen it because he had been knocked unconscious by the accident and had not revived until he was in the ambulance. Brown had a previous conviction for shoplifting. The prosecutor on cross-examination was about to use this conviction to impeach, thus challenging or attacking Brown's credibility and, in turn, the testimony when Brown's attorney objected. The attorney asked for a sidebar conference so that the jury could not hear objection to any questions about the shoplifting conviction. She argued that the conviction, which had occurred 8 years previously, was too remote to be relevant and would constitute undue prejudice. The judge agreed and prohibited any mention of the prior conviction. After a few more questions, the prosecutor concluded his cross-examination, and the defense rested its case. Before we continue with the discussion of closing arguments, let's take a final look at our additional facts from the beginning of the chapter. Here, Mr. Brown discovered the medical records of Clay that showed a past history of drug use and hospitalized for a near overdose. Now, in the civil case, its admissibility may have been questionable as its relevancy was not. Now, in the civil case, the admissibility may have been questionable as its relevancy was most likely outweighed by prejudice. But here, Brown's attorney can make an argument that Clay's medical record shows a prior history of drug use, which may arguably show that Brown had no link to the heroin found underneath the seat. Again, the judge would have to make a determination. But chances are the information was too tenuous to show a connection, or certain evidentiary rules would prohibit its admissibility. Both sides presented their closing arguments following the lunch recess. The judge then instructed the jury. The judge described the elements of the offense and explained that the burden of proof in a criminal case is on the government, the prosecutor. That burden, the judge continued, is to prove each element of the offense beyond a reasonable doubt. This is the standard of proof in criminal cases and is met when there are no doubts about the evidence that would cause prudent people to hesitate before rendering a guilty verdict. A jury must be convinced that there are no other reasonable explanations as to why the crime or actions occurred. The jury took less than 45 minutes to reach its verdict. All parties quickly reassembled in the courtroom to hear the presiding juror, foreperson, announce the verdict, acquitting Brown of the offense. A poll of the jury requested by the prosecutor confirmed the result. Polling a jury means that each member of the jury is asked how they voted in the case, acquittal or guilty. Since the result of acquittal was confirmed, the judge advised Brown that he was free to go. Generally, criminal cases in which the defendant is acquitted may not be appealed by the prosecutor. A second prosecution would be double jeopardy. Hence, in this case, there was no appeal of the trial judgment. If a defendant is convicted, a sentence is pronounced. A convicted defendant does have the right to appeal. The appeals process is similar to a civil proceeding, and the rules of the court where the appeal is filed should be reviewed when an appeal is anticipated and filed. Exhibit 14-8 presents a chart of a criminal case. Exhibit 14-8, chart of criminal case. Arrest of defendant, initial appearance, bail sent and attorney appointed if needed, preliminary hearing, arraignment, entry of plea, guilty, not guilty, or no contest, pretrial activities, prosecutor provides evidence to defendant, and parties file motions such as motions in limine, possible plea agreement between the parties, trial, voir dire of jury, prosecution, opening statement, presentation of witnesses and evidence, cross by defendant, prosecutor rests, trial defense, presents motions to dismiss, opening statement, may present evidence, no requirement, defendant rests. If defense presents evidence, prosecution has rebuttal, closing arguments by the parties, judge instructs the jury, verdict by the jury. After verdict, jury may be polled and defense may make motions. Defense may file an appeal. Three, administrative dispute. The day after his indictment on the felony charge, Brown went down to the state employment office to apply for unemployment compensation. This is where an individual applies for temporary income from the government when they have lost their job, often after being laid off, and are looking for work. After being interviewed by a clerk, Brown filled out an application form. The clerk told Brown that he would receive a letter in about a week notifying him of the agency's initial determination of eligibility. If eligible, the benefits would start in 10 days. Brown received the letter a few days later. It advised that, although Brown was otherwise eligible for benefits, a routine check with a former employer had disclosed that he had been fired for misconduct. For this reason, the letter stated he would be deemed disqualified for a 9-week period. Moreover, the benefits due for those 9 weeks would be deducted from the total amount Brown would otherwise have been entitled to receive. If Brown wished to appeal this decision, the letter went on. He needed to request an administrative hearing within 10 days. In an administrative agency hearing, a hearing officer, like for example an administrative law judge, presides over the matter. They hear the evidence and review any documentation submitted and ultimately render a decision based upon the application of the regulations, statutes, or executive orders that govern the agency. The hearing is usually conducted less formally than a court hearing or trial. Brown felt that he needed some legal advice, but he was still out of work and broke. The lawsuit and the civil action had not been filed yet. It would be well over a year before the case would be tried, the appeal completed, and the judgment award actually paid. Brown, therefore, decided to obtain help from the local legal aid office. This is an office of attorneys and paralegals that provides free or low-cost legal services to persons who cannot afford standard legal fees, also called legal services office. Brown explained his problem to a receptionist and was introduced to the paralegal who would be handling the case. The paralegal, an expert in unemployment compensation law, interviewed Brown and helped him fill out a form requesting a hearing. The paralegal said he would let Brown know as soon as the date was set. Brown left, and the paralegal, after consulting with his supervisor, began to research and draft a memorandum to submit to the hearing examiner on Brown's behalf. In Brown's state, a claimant can have non-attorney representation at unemployment compensation hearings. Therefore, the paralegal at the legal aid office was allowed to represent Brown at his hearing. The only witnesses at the hearing were Brown and their former boss, Frank Best. Best told the examiner about Brown's arrest and about the thefts from the warehouse. Taken together, he argued these events make it impossible for him to trust Brown on the job any longer. Brown, in turn, denied any participation in the thefts and maintained his innocence on the drug charge. Brown had not yet been acquitted of the felony. The hearing examiner at the close of the proceedings thanked the parties and promised a decision within a few days. The hearing examiner's decision was mailed shortly thereafter in a document labeled Proposed Findings and Rulings. These are the recommended conclusions presented to someone else in the administrative agency who will make the final decision on Mr. Brown's case. The last paragraph contained the examiner's recommended decision. The hearing examiner agreed with Brown that his boss's mere suspicion that Brown was involved in the thefts was not enough to justify a finding of misconduct. However, the decision went on. The pending criminal charges for a drug-related offense did provide the employer with good cause or sufficient reason to fire Brown because drug involvement could affect his ability to operate a company vehicle safely. The paragraph concluded by recommending a finding of misconduct and the imposition of a 9-week penalty period. A second mailing arrived 10 days later containing the administrative decision of the agency. The letter, signed by the director of the local agency, adopted the recommended decision of the hearing examiner. Mr. Brown lost. This decision, the letter concluded, could be appealed within 15 days to the State Unemployment Compensation Board of Appeals, a unit within an administrative agency to which a party can appeal an agency decision. Brown immediately appealed. Copies of the hearing transcript, along with memoranda from both sides, were filed with the Board of Appeals. The board, exercising its discretion, refused to allow oral arguments before it and reversed the decision. It issued a short administrative decision stating that Best may have had cause to be suspicious of Brown, but there was not sufficient evidence of actual misconduct on Brown's part. The board, in this final administrative decision, ordered the local office to begin paying benefits immediately, including retroactive benefits to cover the period since Brown had first applied. Best decided to appeal this administrative decision in a state court, allowing additional challenges of administrative decisions are usually by statute or court rule. Best was allowed to do so because he had exhausted his administrative remedies. This is a legal doctrine that states that all dispute-solving avenues that are available in an administrative agency must be exhausted and that all available remedies must be tried before asking a court to review what the agency did. A court generally will not allow a party to appeal an administrative decision until administrative remedies are exhausted. Best filed a complaint in the county court seeking review of the board's decision. Best submitted the entire record from the proceedings below and asked the court for a trial de novo, a way of saying new trial. Brown, now represented by an attorney from the legal aid office, filed his answer and immediately made a motion for summary judgment. The court, upon a review of the record and the pleadings, granted the motion and affirmed the judgment of the Board of Appeals. Best, after discussing the case at length with his attorney, decided against a further appeal of the case to the State Court of Appeals. See Exhibit 14-9 for a summary of the administrative claim process in a California unemployment insurance benefits case. Exhibit 14-9, summary of the administrative claim process in a California unemployment insurance benefits case. California Unemployment Insurance Appeals Board, the Appeal Process Unemployment Insurance Benefits, EDD 1 EDD's decision. EDD sends you a notice of determination. You disagree with EDD's decision and wish to challenge it. You file an appeal with EDD within 30 days. EDD forwards your appeal request and information about your case to CUIAB. CUIAB to a hearing before a judge. A CUIAB field office processes the appeal and schedules a hearing. There are 11 CUIAB field offices located around the state. The field offices sends you a notice of hearing with the time, date, and location of your hearing. A hearing is held with a judge. The judge issues a decision. You agree with decision. End of CUIAB process. You disagree with the judge's decision and file an appeal with the field office within 30 days. CUIAB 3 board review of the judge's decision. The field office forwards the appeal and case information to the board for review. The board reviews the judge's decision. The board issues a decision. End of CUIAB process. If you disagree with the board's decision, you have 6 months to appeal that decision to your county superior court by filing a petition for writ of mandate with that count. (14-3) Alternative Dispute Resolution ADR. As you can see, litigation can be an involved and costly process. Consequently, disputing parties usually spend considerable time and effort trying to avoid full litigation by negotiating a mutually acceptable resolution called a settlement. Negotiations usually begin when the attorney for the aggrieved party sends a demand letter to the other party or the latter's attorney. More letters are often exchanged along with memos and supporting reports. If there is some progress in these initial exchanges, the attorneys will have a number of face-to-face negotiation sessions. If there is some progress in these initial exchanges, the attorneys will have a number of face-to-face negotiation sessions. A more formal method of seeking a settlement and avoiding litigation is called Alternative Dispute Resolution, ADR. Most ADR methods involve a neutral third person in the process. In some kinds of cases in some states, like for example, medical malpractice, parties are required to try ADR before being allowed to have a court trial. Here are major categories of ADR. 14-3A, Arbitration. Arbitration is a method of alternative dispute resolution in which the parties avoid litigation by submitting their dispute to a neutral third person, the arbitrator who renders a decision resolving the dispute. Judicial arbitration occurs when a court refers or orders the parties to arbitration. If the parties have decided on their own to arbitrate the dispute, such as in a contractual agreement, the arbitration is called contractual arbitration or private arbitration. Many consumer purchase contracts and service agreements have a clause in which both sides agree to use arbitration if a dispute arises. Many union contracts, such as collective bargaining agreements, often have a provision within the contract that requires arbitration of any disputes between the parties. Also, consumer-based contracts often have arbitration clauses as well. Think of contracts involving software or household appliances. Contractual arbitration is used extensively. One paralegal points out that we live in an age where everything from your bank account to the forms you fill out in a doctor's office contain a clause requiring any dispute that arises to be resolved by arbitration. Hence, when disputes arise in these situations, the modern paralegal is far more likely to help prepare for arbitration than for trial. Only a small minority of cases go to trial, and that is partly because more and more disputes are governed by arbitration. In both judicial and contractual arbitration, the arbitrator listens to the evidence and makes a decision, often called an award. Arbitrators are not necessarily judges or government employees. They do not have to be attorneys. They are often hired through organizations such as the American Arbitration Association, www.adr.org. An arbitration proceeding is not as formal as a court trial. Elaborate objections to evidence, for example, may occur in court cases, but they are relatively rare in arbitration proceedings. Parties appear before the arbitrator on their own or through their attorneys. Both judicial and contractual arbitration can be binding or non-binding. The parties decide. If they choose binding arbitration, the arbitrator's decision is not appealable to a court or is subject to limited court appeal. In non-binding arbitration, a party who is unhappy with an arbitrator's decision can appeal the decision in court. If, however, the end result of the court appeal is the same as the arbitration decision, or is more favorable to the other party, some states will punish the party who appealed by making them pay the attorney's fees and costs incurred by the other party in litigating the case in court. Analyze this. Find examples of arbitration clauses in your daily life. For example, check your software agreement for a software program that was purchased, or review the terms and conditions of an appliance that you purchased, or check the terms and conditions on a website that you often visit and see what you have agreed to. Compare two of the arbitration clauses and identify the differences. Does the arbitration clause state who pays the costs of the arbitration and where the arbitration will take place? 14-3B, mediation. Mediation is a method of ADR in which the parties avoid litigation by submitting their disputes to a neutral third person, the mediator, who helps the parties resolve their dispute but does not render a decision that resolves it for them. The mediator, however, may make suggestions or recommendations for a resolution. Parties appear before the mediator on their own or through their attorneys. Mediators do not have to be attorneys. A variation on this ADR is called binding mediation, in which the mediator does render a decision that resolves a dispute, but only after the parties have attempted mediation and failed. This is similar to med-arb, discussed next. Quick tip: many courts now have court-ordered mediation rules and procedures. Check your jurisdiction's rules to determine what process, if any, that the court has regarding mediation. Check your jurisdiction's rules to determine what processes, if any, the court has regarding mediation opportunities. Mediation also may be ordered in the appellate courts, such as federal appeals courts. 14-3C, med-arb. Med-arb is a method of ADR in which the parties first try mediation, and if it does not work, they try arbitration. Once it is clear that mediation will not be successful, the mediator can switch roles and make a decision as an arbitrator. 14-3D, private judging. Private judging is a method of ADR consisting of arbitration or mediation, in which the arbitrator or mediator is a retired judge. A retired judge has no more authority or power than any other arbitrator or mediator. Private judging is a non-government proceeding. However, because of a retired judge's knowledge, some individuals, companies, or agencies seek out retired judges as mediators or arbitrator, especially in complex legal matters such as contract disputes. 14-3E, neutral evaluation. Neutral evaluation is a method of ADR in which both sides hire an experienced attorney or an expert in the area involved in the dispute, like for example a chemist in a patent dispute, who will listen to an abbreviated version of the evidence and the arguments of each side and offer an evaluation in the hope that this will stimulate more serious settlement discussions. The process is sometimes called case evaluation. 14-3F, summary jury trial, summary bench trial. In a summary jury trial or summary bench trial, the attorneys present their cases in summary form without calling witnesses. A jury listens to the attorneys if a summary jury is used. A judge listens to the attorneys if a summary bench trial is used. The jury or judge will then reach a non-binding conclusion on the dispute. The hope is that this conclusion will encourage the parties to settle. If the settlement efforts fail, the case goes to trial. The parties begin anew as if the parties begin new as if the summary jury or bench trial had not occurred. 14-3G, collaborative law. Collaborative law is a method of practicing law in which the attorneys refuse to continue representing the parties if they cannot settle their dispute through mediation or other method of ADR. The goal is to encourage settlement. If ADR fails and the parties want to start litigation, the collaborative law attorneys withdraw from the case so that the parties must now find litigation attorneys. The cost of paying for a new set of attorneys is a strong incentive to settle. 14-3 online ADR or virtual ADR. Parties can engage in ADR online or virtually. This is not a new solution in the ADR field, but it gained prevalence during the pandemic of 2020. Online or virtual ADR is an alternative to in-person ADR. It generally works the same, except the parties are either on the phone or on a video conference, such as Zoom or Teams. Virtual ADR allows the parties to participate remotely rather than in person. In today's global world, it is often not practical for parties to meet in person. This may be due to a variety of reasons, such as schedules, distance, financial constraints, or simply the inability to meet in person because of age, infirmity, or otherwise. Virtual ADR is just as effective as in-person ADR and has many advantages. Virtual ADR proceeds just like in-person ADR with the mediator managing the sessions. If there was one positive that came from the pandemic, was the realization that almost anything can successfully be done virtually. Online exercise. Determine whether your state courts have ADR-sponsored programs for litigants. If so, review and outline the process and add to your portfolio binder. 14-3I, litigation support. Roles in ADR. Paralegals have many roles in assisting attorneys who have cases in ADR. For example, a paralegal can organize files, schedule discovery and ADR sessions, conduct investigations, summarize or digest data from discovery, help prepare the client for ADR, and assist the attorney during the ADR proceeding. In much the same fashion as paralegals assist attorneys during regular trials. Paralegals often prepare mediation summaries, particularly in personal injury cases, that outline the issues of the case, present the facts, including a description of the incident, List the medical expenses and lost wages incurred by the client. Summarize medical records and state the costs incurred by the law firm to date. Some firms use a standard form for this, where you simply insert the information. One paralegal helps their attorney prepare for mediation by scanning all documents and supportive evidence into the attorney's laptop computer and making a PowerPoint presentation of this data that the attorney can use during the mediation session. If ADR leads to a resolution of the case, paralegals can be involved in finalizing the settlement, such as by preparing a draft of the document that lays out the terms of the agreement that the parties reached. In addition, some paralegals have become arbitrators and mediators themselves. In most states, as indicated, you do not have to be an attorney to conduct arbitration or mediation. However, it is advisable or prudent to engage in a class or training that assists prospective mediators and arbitrators in the art of negotiation and settlement. Service companies are available that offer arbitration and mediation services to parties involved in disputes. A few of these companies hire people with paralegal training and experience to be arbitrators or mediators. (14-4) Litigation support. The role of the paralegal in the pretrial stage. Trial work can be challenging because of the high stakes and high energy involved. Litigation paralegal Jennifer Swales assists lawyers with everything from submitting the first draft of discovery to following through the Litigation paralegal Jennifer Swales assists lawyers with everything from submitting the first draft of discovery to following through to the end of a trial. Recalling her first trial, she remembers experiencing every possible emotion. I was scared to death, nervous, and tired. Not all paralegals, however, have the same responsibility during litigation. Some, like Jennifer, perform a broad range of tasks. Others are given more narrow litigation tasks. Let's take a closer look at this variety of paralegal roles during litigation, beginning with the pretrial stage. At the pretrial stage, many paralegal tasks fall into the following categories. 1. Pleadings. 2. Service of process and court filings. 3. Calendar control and scheduling. 4. Discovery. 5. Trial notebooks. 6. Settlement. 7. Expert witness. 8. Interviewing. 9. Investigation. 10. Legal research. The remainder of the chapter will cover most of these tasks, particularly those at the beginning of the list. Some are also discussed in Chapter 5 on law office administration, Chapter 9 on legal research, Chapter 11 on computers in the law, Chapter 12 on interviewing, and Chapter 13 on investigation. 1. Pleadings. The major pleadings in litigation are the complaint and the answer. Very often a law office will use standard forms as the starting point in drafting pleadings or instruments, such as a will, contract, or mortgage. These standard forms come from old case files or from templates and document assembly programs, which we examined in Chapter 11. For example, once you have typed the basic format of a complaint, you can save the format for reuse in other cases. The format typically includes the heading of the complaint, the spacing between lines, the consecutive numbering of each line, if this is required by court rules, etc. Standard forms. Before we look at an example of a standard form for a complaint, we need to cover some basic guidelines on the need to adapt such forms to the needs of current clients. The guidelines are as follows. Find a standard form. A standard form is an example of the document that you need to draft. It could be a pleading, like for example a complaint, or an instrument, like for example a contract. Standard forms are found in a number of places: form books, manuals, practice texts, statutory codes, and court rules. Standard forms are found in a number of places: form books, manuals, practice texts, statutory codes, and court rules. Computer templates and document assembly programs are also used as starting points for creating standard forms. Standard forms or examples can be found online, although most standard forms are written by private attorneys. Occasionally, however, a standard form will be written by the legislature or by the court as the suggested or required form to use. So when you are beginning the drafting process, check the court websites to determine whether standard forms are available to follow. Adapt the form to your case. Considerable care must be exercised in the use of a standard form. A form can be deceptive in that it appears to require you to do little more than fill in the blanks. The intelligent use of these forms usually requires much more. The cardinal rule is that you must always adapt the form to the particular law and facts of the client's case. You fit the form to the client's case, not the client's case to the form. If there are facts already in the form, be sure that those facts are consistent with the facts of your client's case. Clauses may have been included in the form to cover specific legal requirements. You must decide if these clauses are needed by the client and if other clauses must be added to cover the client's situation. Do not be reluctant to change the pre-printed language in the form if you have a good reason. Whenever you make such a change, be sure to alert your supervisors so that it can be done. Whenever you make such a change, be sure to alert your supervisor so that it can be approved. Know the meaning of the legal terms and their application. You should never use a standard form until you have satisfied yourself that you know the meaning of every word and phrase on the form. This includes boilerplate, which is standard language commonly used in the same kind of document. Too often, form users ignore what they do not understand. Find out what everything on the form means by using a legal dictionary, often a good starting point. Using a legal dictionary, which is often a good starting point. Asking your supervisor, asking other knowledgeable people, doing other legal research. Once you have found a form that appears useful, look around for another form that attempts to serve the same purpose. Analyze the different or alternative forms available. Which one is preferable? Why? Keep questioning the validity and effectiveness of any form. If you leave any blank spaces on the form, be sure that your supervisor approves leaving them blank. Research the law and be sure your form is current. Knowing the current state of the law is critical when preparing any form document. Often you will go to an old case file to find a document that can be used as a model for a similar document that you need draft. Often you will go to an old case file to find a document that can be used as a model for a similar document that you need to draft on a current case. However, laws change, and a form from 5 years ago may give you a good base, but the law may have changed during that time period. Verify the law is current before beginning the draft of any form document. Additionally, if the form was written for another state, be aware that the form may be unadaptable to your state because of differences in the laws of the two states. Old files are only a guide. Often you will go to an old file to find a document that can be used as a model for a similar document that you need to draft on a current case. All the above cautions apply to the adaptation of documents from other files. Remember that old case files are just that, old case files. Use old files as a guide, but craft your document according to the specifics of the case you are currently working on. Inclement vs. Public Service, Electric and Gas Co. 198 FRD 198 D&J 2001, and its related case Clement vs. Public Service, Electric and Gas Co. 122F Supplement 2D 551 D&J 2000. An attorney was sanctioned for failing to read forms in a case where a complaint was filed that raised causes of action that could not have remotely applied to the defendant. Public Service, Electric and Gas Co. The court was not shy is expressing its consternation for for the attorney's actions in which colorful language was used to express disdain for the attorney's practices. Order of the Court, a case study, Clement v. Public Service Electric and Gas Co., United States Court for the District of New Jersey, 198 FRD, 198 FRD, 198 D&J 2001, Clement v. Public Service Electric and Gas Co., 122 FSUPP 2D 551 D&J 2000. The facts in Clement v. Public Service Electric and Gas Co. stem from a civil rights action by Mark Clement against the public utility Public Service Electric and Gas Co. Based on the facts in the 2000 case, Clement was a 36-year-old black male who was employed by E.P. Henry on November 19, 1999. Clement got into a dispute with a PSEG employee in the parking lot where racial slurs were made against Clement. Clement claims that he was intimidated and humiliated, causing him to suffer emotional distress requiring medical treatment. The problem, as the court noted, was that Clement's attorney, Lorraine Harris, pleaded allegations in the Clement's complaint that were legal impossibilities that drew the IRE of the court. Harris claimed in her complaint PSEG's conduct was in violation of the Opposition Clause, as well as the Civil Rights Act of 1968. The initial problem is that the Opposition Clause applies in an employer and employee context, of which Clement was not. The court's first complaint with Ms. Harris was why and how could she plead an action that was obviously inapplicable. Her response, as noted in the 2001 case, was that she used a form and just filled in the information. She also stated that the statutory section was hundreds of pages and too long to read, so she did not realize that the Opposition Clause did not apply. Similarly, in her civil rights allegations, Harris failed to allege facts applicable to the situation. As the court stated in the 2000 case, she failed to allege facts showing that in this circumstance, Civil Rights Section 1983 applied to PSEG, in that it was a state actor, acting in the shoes of a state sovereign. Both causes of action were found wholly inadequate, with the court dismissing the complaint and giving Harris an opportunity to amend the complaint. But that is not the end of the story. The court in the 2000 case issued a show cause order requiring Harris to justify her actions. What followed was the 2001 case, with the court leaving no misunderstanding as to its position. In the 2001 case, Harris filed an affidavit attempting to justify her actions and lack of research. She stated that she used a form complaint found in a practice manual and believed that the facts were applicable to the form, which had boilerplate language for an opposition clause. Based on Harris's admission, the court's response was particularly biting when it said Harris copied a form complaint out of practice manual without regard to the facts and law applicable to this case. Attorneys who merely copy form complaints and file them in this court without conducting independent legal research and examining the facts, giving rise to a potential claim to do so. Attorneys who merely copy form complaints and file them in the court. Attorneys who merely copy form complaints and file them in this court without conducting independent legal research and examining the facts, giving rise to a potential claim, do so at their peril. Lawyers are not automatons. They are trained professionals who are expected to exercise independent judgment. ID at 6:36. And then Harris tried to explain why she missed a deadline to timely file a charge with the Equal Employment Opportunity Commission, EEOC. Here, she simply stated that there were too many pages to read for her to know that she missed a procedural requirement, not a satisfactory response. The court found Harris's responses mind-boggling and called her incapable of understanding why and where she went wrong. With the other claims, the court continued its pointed comments and then went on to discuss the standards for Rule 11 sanctions. In this case, the court determined that money sanctions were not sufficient or appropriate. The court found that a public admonition was warranted. In addition, Harris was to enroll in and complete basic legal educational courses, and that a further investigation be conducted by the appropriate authorities to determine whether Harris was competent to practice law. ID at 637, ouch. Discussion questions. Review Claimant vs. Public Serve Electric and Gas Company 2000 and 2001. What was the basis for PSEG motion to dismiss? What is an opposition clause, and did it not apply in this case? What is a Rule 11 motion, and what are its standards? Was the court too harsh on claimant's attorney? Defend your answer. Complaints. Recall the complaint. Recall that the complaint is the document that starts a lawsuit. The information within the document will always change, but the format is generally the same for all jurisdictions. However, before you begin drafting a complaint, check the formatting and legal requirements for the jurisdiction for which you are drafting the complaint and noted in Claimant vs. Public Service Electric and Gas Company above. Exhibit 14-10 illustrates the basic structure of many complaints. Note that the complaint includes the following components. Exhibit 14-10, structure of a complaint. The Superior Court of, write the state, county of, write the county, caption, name of plaintiff, verse, name of the defendant, docket number, write the docket number, complaint for negligence, designation of pleading, statement of jurisdiction. The plaintiff through their attorney alleges, write what the complaint is and what the plaintiff is alleging. The jurisdiction of this court is based upon section, write the section, title, write the title of the state code. Facts relevant to venue. 2. The plaintiff is an accountant who resides at 12 Arch Street in the city of, write the city, county of, write the county. She has resided here for 5 years immediately preceding. She has resided here for 5 years immediately preceding the filing of this court. She has resided here for 5 years immediately preceding the filing of this complaint. 3. Upon information and belief, defendant is a truck driver who has resided at 465 Hamilton Street, city of, write the city, county of, blank, for an indefinite period. Body of complaint. 4. On March 13, 2022, the truck of defendant collided with the car of plaintiff. This occurred on the corner of 1st Street and Via Dios in the city of, write the city, county of, write the city, write the county. 5. The collision occurred as a result of the negligent operation of the defendant's truck as to speed and control of his truck. 6. As a result of the negligence of the defendant asserted in paragraph 5, the plaintiff has been subjected to great pain and suffering and has incurred medical expenses, loss of income, and automobile repair expenses. Prayer for relief. 7. Therefore, plaintiff demands judgment in the amount of $350,000 plus the costs and disbursements of this action. Jury demand. 8. The plaintiff demands a trial by jury on all issues so triable. Subscription. A signature block respectfully submitted. Taylor Marcus Esquire, Windsor, Chan and Marcus, LLC. Attorney for plaintiff. Address, telephone number, fax number, bar number, email address. State of, right to state. County of, right to county. Verification. Adrian Smith, being first duly sworn on oath according to law, deposes and says that she has read the foregoing complaint and that the matters stated therein are true to the best of her knowledge, information, and belief. Subscribed and sworn. Notarization. Subscribed and sworn to before me on this day, right, the day of, right, what month? 2000 and, right, the year. Notary public. My commission expires right when the commission expires. Caption, designation of pleading, statement of jurisdiction, facts relevant to venue, body of complaint, prayer for relief, jury demand, subscription, verification, notarization. Not all complaints will contain these components. You need to check the requirements in the statutes and court rules that govern the structure for complaints in the court where your office is filing the action. Detailed requirements may exist on matters such as size, weight, and type of paper that can be used, permissible margins, font and type size, line spacing and numbering, and the use of a colored backing to which the complaint may have to be fastened. Online exercise for your state. Find the requirements for preparing a complaint in any of your trial level courts. Determine if any of the judges in your local area courts have special requirements for filing a complaint in their courts. These may be found in the local rules of the court or a court website. Electronic filing, e-filing of complaints and other pleadings is discussed in the next section. Caption of complaint. A caption of a complaint is the heading that provides identifying information, such as the kind of document it is, the name of the court, the name of the parties, and, if available, the docket number assigned to the case by the court. Sometimes attorneys do refer to the caption as the heading of the case and are used interchangeably. Designation of the pleading. The title of the pleading is stated at the top of the pleading as part of the caption. The pleading for our example in Exhibit 14-10 is a complaint for negligence. Quick tip, not all jurisdictions use the term complaint for the first document that is filed with the court in a case. You may see designations such as petition, information, and other terms that various jurisdictions use. Research the pleading designation that is required for the document you are filing. Statement of jurisdiction. If the court requires a statement of the court's subject matter jurisdiction, the citation to the statute or other law conferring this jurisdiction must be included. Subject matter jurisdiction is the court's power to resolve a particular type of legal dispute and to grant a particular type of relief. The main federal trial courts, U.S. district courts, require a statement of subject matter jurisdiction in complaints. Rule 8 of the Federal Rules of Civil Procedure, FRCP, provides that a claim for relief shall contain a short and plain statement of the grounds for the court's jurisdiction. Not all states have the same requirement. Some state courts require a statement of subject matter jurisdiction, others do not. Venue. For purposes of determining venue, The complaint may also have to allege the residence of the parties where the accident or wrong allegedly occurred. Venue is the proper county or geographical area in which a court with jurisdiction may hear a case. In most judicial systems, there is more than one trial court. For example, there may be one for each county or district. The selection of a particular trial court within a judicial system is referred to as a choice of venue. Body of complaint. The claims or causes of action of the plaintiff are stated in the body of the complaint. A cause of action is a legally acceptable reason for suing. A set of facts that gives a party the right to. A cause of action is a legally acceptable reason for suing. A set of facts that gives a party the right to judicial relief. Every separate cause of action used by the plaintiff should be stated in a separate count, like for example count 1, count 2, or simply as first cause of action, second cause of action, etc. This is not done in Exhibit 14-10 because only one cause of action is alleged in this complaint, and negligence. This is not done in Exhibit 14-10 because only one cause of action is alleged in this complaint, which is negligence. Throughout the complaint, the paragraphs should be consecutively numbered. Each paragraph in the body should contain a single fact or a closely related group. Each paragraph in the body should contain a single fact or a closely related grouping of facts. In federal courts and in many state courts, the complaint does not have to state every detail of every fact that the plaintiff will try to prove in the trial. These courts require only notice pleading, which is a short and plain statement of the claim showing that the pleader is entitled to relief. There are times, however, when specificity in the pleading is required. For example, allegations of fraud must be stated with a specificity or particularity. Also, when special damages are sought in defamation cases, the facts must be pleaded with specificity. When detailed facts are required in the complaint, such as Texas and New Jersey, this is known as fact pleading. Fact pleading requires specific detailed facts to support the underlying causes. Fact pleading requires specific detailed facts to support the underlying cause of actions pled in the complaint. Thus, the comprehensive details of the basis of the complaint filed against the defendant. Analyze this. Determine whether your state is a fact pleading or a notice pleading state. When the plaintiff lacks personal knowledge of a fact being alleged, the fact should be stated upon information and belief. When the plaintiff lacks personal knowledge of a fact being alleged, the fact should be stated upon information and belief. As in the third paragraph of Exhibit 14-10, prayer for relief. In the prayer for relief, the complaint asks for a specific amount of damages or for some other form of relief, such as an injunction against a nuisance. Think of the prayer for relief as the section of the complaint that tells the court what you want, the remedy. If the prayer asks for damages, the clause requesting it is called the ad demum clause. If the defendant fails to appear and answer the complaint, a default judgment is entered against the defendant. The relief given the plaintiff in a default judgment cannot exceed what the plaintiff asked for in the prayer for relief. A default judgment is a judgment against a party for failure to file a required pleading or otherwise respond to an opponent's claim. Demand for a jury trial. Not all cases can be tried by jury, although negligence cases between private parties usually can. If a plaintiff in a civil negligence case wants a jury, most states require a request demand for a jury to be made in the complaint. Sometimes the demand for a jury trial is at the end of the document or may be in the beginning. Check your jurisdiction's requirements for demanding a jury trial in the complaint. Subscription or signature block. A subscription is someone's signature. If an attorney wrote the complaint, their subscription is required. If the plaintiff wrote the complaint and is acting as their own attorney in the case, the plaintiff signs. A less formal and more commonly used term for the subscription is the signature block. Many jurisdictions have specific requirements for the signature block, such as complete address, attorney bar number, contact information, and party represented. Additionally, when an attorney signs a complaint, legal responsibilities flow from that filing as well as any future filings with the court. The attorney filing the complaint must have a good faith basis for filing the document, and thus must not be a frivolous filing. The Federal Rules of Civil Procedure that addresses this issue is Rule 11. See Clement v. Public Service, Electric and Gas Company above. Quick tip: you will hear attorneys say that they are going to file a Rule 11 motion against an attorney. They are referring to the Federal Rule of Civil Procedure, Rule 11, and are voicing concern that the pleading filed was They are referring to the Federal Rule of Civil Procedure, Rule 11, and are voicing concern that the pleading filed was frivolous, not in good faith, and often filed for purposes of harassment. This is a very serious charge and has legal consequences such as sanctions if proven. Verification. A verification is a formal declaration stating that a person has read a document, like for example a complaint, and swears that it is true to the best of their knowledge. Not all courts require a verification, nor do all complaints. When required, it is signed by a party on whose behalf the pleading is prepared. Notarization. If court rules require notarization, the notary's seal is usually placed at the end of the complaint. Civil cover sheet. Along with the complaint, the plaintiff must file a civil cover sheet, which is a form filed in court in a civil case that indicates the names and addresses of the parties and their attorneys, the kind of action being filed, and general information required by the court. See Exhibit 14-11 for an example of a civil cover sheet in a federal complaint. Exhibit 14-11. Example of civil cover sheet in federal court cases. Example of civil cover sheet in federal court case. (14-4B) Other pleadings. The response of the defendant is the answer, which is the first pleading filed by the defendant that responds to the plaintiff's claims. The answer may simply deny the assertions in the complaint. The answer can also assert an affirmative defense, which raises facts or arguments that will defeat an opponent's claim, even if the opponent's allegations in the claim are proven. If the defendant wants to assert a claim against the plaintiff, it is done in a counterclaim. See the previous discussion earlier in the chapter. 2. Service of process and court filings. The lawsuit begins with the service of process, which is a formal delivery of notice to a defendant that a suit has been initiated to which a response is required. The defendant receives a copy of the complaint and summons. The latter is a notice directing the defendant to appear in court and answers the plaintiff's complaint or face a default judgment, which is a judgment against a party for failure to file a request required pleading, or otherwise respond to an opponent's claim. Delivery of the complaint and summons to the defendant is usually accomplished in person. An adult, someone other than the plaintiff, hands the documents to the defendant. Under some circumstances, the law allows substituted service, such as by registered mail. Before substituted service is allowed, the plaintiff may be required to file an affidavit on the efforts taken to find the defendant in the state. Another service task involves witnesses or a call to appear for a deposition, for a court hearing, or for the trial itself. To compel witnesses to appear, they are often served with a subpoena. Which is a command to appear at a certain time and place. If the command is to bring documents or things, it is a subpoena ducis tecum. A paralegal may be asked to serve process or to serve a subpoena. Alternatively, the law firm may hire a service company that is a professional process server. If so, a paralegal may have the responsibility of hiring and monitoring the company. Completing a service yourself takes preparation and care. You must know the local rules on how to serve someone properly. In addition, you need to anticipate the kinds of difficulty you might encounter on the street. Here is how paralegal David Bush describes the first service assignment he was given. I was given a subpoena to serve on a lady for a hearing the next day. I rushed to the courthouse to pick up the subpoena and immediately proceeded to the address given to me by the attorney. I spent over an hour looking for the address when I realized that it was a bad address. I frantically tried to call the lawyer. He was in court. His secretary gave me a work address. I rushed to the work address to find out that she was on vacation for 2 weeks beginning yesterday. Frustrating. This was my first service, and I could not even find the lady. I realized that process serving is not as easy as handling someone a copy of a lawsuit. Filing documents in court also requires careful preparation and compliance with court rules. Court clerks usually have little sympathy for filers who fail to comply with such requirements. But note, the physical in-court filing is used less and less today in electronic. But note, the physical in-court filing is used less and less in today's electronic world. Sometimes the initial complaint may be filed physically with the court, but more often than not, complaints as noted in this section will be filed electronically. What is important is know the rules of the court in which you are filing or serving a complaint, or any pleading for that matter. At some point in the near future, all filings, whether state or federal, will be filed electronically. The exception may be a pro se filing by an unrepresented party. If you are needing to file a document directly with the court, known as a conventional filing, litigation paralegal Aaron Schlemme recommends the following basic steps for successful filings. Know the correct address of the court where the filing must be made. Phone in advance or check the court's website to determine the exact hours when the clerk's office will be open to accept filings. Use the correct format, including the proper size of paper, content of the cover sheet, and etc. Have the correct fees, and know whether the clerk can accept a personal check or a law firm check or credit card. The traditional method of initiating a lawsuit is to go to the court clerk and hand over the original complaint, a copy to leave with the court, and copies for each of the parties. The clerk assigns a docket number or special computer coding number to the case and stamps this number on the original and on each of the copies. The date is also stamped on the front of the original and each copy. Most courts require the summons to be attached to the complaint. Most courts, however, now use electronic filing, referred to as e-filing, which can occur at any hour of the day, on any day of the week. Of course, as with traditional filing, deadlines must be met. A cause of action can be lost if not filed by hand or electronically before the statute of limitations expires. In federal courts, trial, bankruptcy, and appellate, the e-filing system is called Case Management and Electronic Filing, CMECF. The system for gaining access to the 500 million case file documents is called The system for gaining access to the 500 plus million case file documents is called Public Access to Court Electronic Records, PACER. Most state courts have their own systems for e-filing and access. In one county in Arizona, for example, the online system for state courts is called Electronic Court Record, ECR. Great care is needed in order to use these systems correctly. Special rules apply. Here, for example, is the rule in one state. Any document that is electronically filed with the court after the close of business on any day shall be deemed to have been filed on the next court day. Close of business, as used in this paragraph, shall mean 5 p.m. or the time at which the court would not accept filing at the court's filing counter, whichever is earlier. Online assistance is often available to learn the e-filing system, including its special rules and the mechanics of navigating the system. E-filed documents are often presented in an image or digital format, the most common being PDF. Portable document format. A document as a PDF file is a digital document that preserves all the features and styles of the document before it was converted into a digital document. When you read a PDF file, you are reading an exact duplicate of the original document. A special code in the program allows a user to insert a digital signature that verifies the authenticity of the document you are sending. To read PDF files, many law firms use free or paid versions of Adobe products. The PDF standard is not the only format used in e-filing systems. Another is the XML, Extensible Markup Language Standard. Quick tip: one of the main reasons to convert a Word document into a PDF is because a Word document is easily changed, whereas a PDF is not. Some court filing systems will reject the document if it is not filed in the required format, such as PDF. Others automatically convert it. Know your electronic filing system requirements. 3. Calendar control and scheduling. Keeping an updated and accurate calendar is essential for legal professionals. Calendars keep court dates, due dates, meetings, and any other date that is important in the life of a legal professional. Consequently, here are 5 words that a paralegal and anyone else in a law office should never be heard saying. "Oh, was that due today?" The clock is a dominant presence in every well-run law office. The calendar control is so critical that some legal malpractice insurance companies will not insure attorneys that do not have approved reminder systems built into their case management program. One of the most common grounds for legal malpractice claims against attorneys is allowing the statute of limitations to run on a cause of action. The failure to file a lawsuit within the time allowed by law can result in the permanent loss of a client's right to assert a cause of action. No matter how good a case the client would have had in court, the task of controlling dates and schedules can become all the more hectic. When unanticipated events force an office to recalculate large numbers of due dates. One paralegal recalls a time when a judge unexpectedly postponed a trial that was about to begin. Here we are 3 days before trial, and everything comes to an abrupt halt. The parties had subpoenaed over 20 witnesses, rooms had been served, equipment had been rented, expert witnesses had been prepared, and numerous exhibits were ready to be used. Suddenly, the judge's clerk called to announce a 2-month postponement. In this environment, a major method of achieving calendar control is the tracking system called the tickler. This is a paper or computer system used to record important dates and to remind everyone to take appropriate action on these dates. A key responsibility of many paralegals is to operate and monitor these tracking or calendar systems. Attorneys need constant reminders of due dates, particularly when they are working on more than one case and when more than one attorney is working on a single case. Ticklers operate in different ways. Most offices use computer programs that have reminder or tickler systems built into them. Case management and calendar software programs can automatically send out email reminders as the date of a calendared event approaches. Once you insert future events in the online calendar, you can receive pop-up reminders and beep sounds prior to and on the dates. Once you insert future events in the online calendar, you can receive pop-up reminders and beep sounds prior to and on the due dates indicated on the calendar. The software can be keyed to the deadlines found in court rules of particular courts. When you tell the software what kind of case you have and the date on which you filed your complaint, you'll be given alerts on when litigation events must occur, such as the date when the answer must be filed, the earliest date when discovery can begin, to name a few. Online calendaring services of this kind are also available. Some offices still use a manual or paper tickler as a backup to the computer tickler. Suppose, for example, that an attorney must conduct a deposition on May 23rd, weeks before this date. The attorney's paralegal will enter this date on a specially designed multi-part form. One of the parts of the form is torn off and sent to the attorney as a reminder of the deposition. Another part will be torn off and sent to the attorney as a further reminder a few days before May 23rd. In addition, secretaries, paralegals, and attorneys would enter the same due dates in their individual diaries. An important calendar control is redundancy, meaning more than one system to accomplish the same task. For example, there could be a central computer tickler for all cases in the office, a separate tickler built into the case management software used on a particular case, a manual tickler, and individual diaries. With these tools, the likelihood of missing a date is substantially decreased. 4. Discovery. Methods of discovery. As discussed previously, there are different forms of discovery available to parties in a lawsuit. These methods of discovery help a party prepare for trial. With the following discovery methods available: deposition. A deposition is a method of discovery where parties or witnesses are questioned by the opposing party prior to trial, either orally or by written questions. The person questioned is called the deponent. Notice to the opposing party is required before a deposition may be taken. Questioning a party cannot go on for as long as the parties like. The rules impose limitations of 1 day with a maximum of 7 hours unless a court permits otherwise. The basic requirements for depositions are governed by Federal Rules of Civil Procedure, Rules 30 and 31, or the state equivalent rule. A party may request that documents be produced for the deposition. This is known as a deposition subpoena ducis tecum. That's just a lawyer's way of saying that the witness must bring requested documents to the deposition so the attorney can review and question that witness on those documents. A deposition is performed before a court reporter who swears in the witness to tell the truth. The deposition can be used at trial or other court proceedings if necessary. Interrogatories, ROGs, ROGS. Written questions may be submitted to the opposing party for which a response in writing is required. These are known as interrogatories and are limited to the parties in the case. Interrogatories have rules regarding its number, which are located in Federal Rule of Civil Procedure Rule 33, or the state equivalent. Interrogatories must be responded to within 30 days from receipt unless a different date is agreed to by the parties or by court order. Request for admission, RFA. Another method of discovery is the request for admission. A request for admission asks, through an affirmative statement, a party to admit or deny the truth of the statement under oath. This is a method particularly helpful in determining the validity of a document, such as a contract. If a statement is admitted, the statement is considered to a conclusive fact for purposes of the case and can be used at trial. Federal Rule of Civil Procedure Rule 36 governs request for admission. Request for production, RFP, of documents and things. Request for entry on land for inspection and other purposes. Under Federal Rule of Civil Procedure Rule 34, a party can request that the opposing party produce documents related to cases. Those documents can be electronic, paper, or any other tangible thing for copying or inspection. Given the magnitude of electronically stored data, special rules have been created in their production. The production of electronic material has become so specialized that legal professionals specialize in electronic data production and related areas. This is an area that has become very prominent for paralegals. Additionally, a discovery request can be made to enter the party's land for inspection under the rules as well. This method of discovery may be used when a real property dispute arises. For example, independent medical examination, IME. Often used in personal injury cases, Federal Rule of Civil Procedure Rule 35 permits a party to have a party whose physical or mental condition is relevant to the case have medical examination. Often used in independent medical examination, IME. Often used in personal injury cases, Federal Rule of Civil Procedure Rule 35 permits a party to have a party whose physical or mental condition is relevant to the case have medical examination. This type of examination is generally limited to the parties in the case. Discovery is used by parties to force information from each other to aid in trial preparation. There are many tasks paralegals can perform during the discovery stage of litigation. For example, when responding to discovery requests, they can help prepare the privilege log that lists all of the information or documents that the office will refuse to disclose because of a claim of privilege, such as the attorney-client privilege. That privilege protects communications between attorney and client that are part of the legal services the attorney is providing the client. If only part of a document is protected by privilege, the paralegal can be assigned the task of redacting, blocking out, or shielding the part that is not discoverable so that the rest can be disclosed. E-discovery. The information obtained in discovery can consist of written answers to questions, like, for example, what doctors treated you in the last 5 years. Documents, like, for example, provide bank records for the last 3 years and the large quantities of e-evidence that are now part of many lawsuits. E-evidence is known as electronically stored information, ESI. When e-evidence is sought in discovery, the process is called e-discovery or electronic data discovery, EDD. Evidence consists of email, instant messages, IMs, text messages, voicemail, social media posts, spreadsheets, websites, digital video, and other digital data. Because storage of digital data is relatively expensive, many companies keep tremendous quantities of data in their offices. In addition, a recent trend is to store digital data in the cloud, meaning in secure sites online. eDiscovery seeks two broad categories of relevant digital data: current data and legacy data. Current data is information that is in current or recent use, like, for example, a list of customers or an exchange of emails from merger negotiations. Legacy data is large, inactive data that is part of the history of the company and that may have been collected on now outdated technology. Paralegal roles in the discovery process. The role of paralegals in the discovery process cannot be understated. They are critical to the process, from assisting in preparing documents, keeping tracking of deadlines, and everything in between. Depending on the complexity of the case, the paralegal can assist in a myriad of ways in the discovery process, such as the following: 14-F depositions.
A scheduled time and place for the deposition, whether in person or electronically, which may include arranging for scheduling and payment of a stenographer or reporter. B, prepare the subpoena, which orders a non-party to come to the deposition to be deposed, or prepare subpoena ducis tecum, which requires the deponent, the witness being deposed, to bring specified things, like, for example, documents with them. When a client is being asked to bring things to the deposition under a subpoena ducis tecum, prepare the privilege log in order to have a list of what is not discoverable by the other side in discovery. D, prepare exhibits the attorney will use when questioning the deponent. E, prepare a list of suggested questions for the attorney to ask the deponent. This is done after reading everything in the file to date, like, for example, complaint answer, interview reports, investigation reports, and answers to interrogatories. F, attend the deposition and take notes and order transcript of deposition after completion. G, make entries in office tickler on due dates for scheduled depositions and related court motions. H, prepare motion to force compliance by other side. I, prepare motion to have matters not answered deemed admitted. J, prepare an index of the deposition testimony. The index should include an alphabetical list of all major topics covered in the deposition. K, digest, summarize the deposition testimony. See Exhibit 14-12 for different ways to prepare digests. L, compare the deposition testimony with the answers to the interrogatories. Identify patterns, look for inconsistencies, etc. Exhibit 14-12, examples of different styles of deposition digests.
Exhibit 14-12, examples of different styles of deposition digests. Page line digest, page lines, summary. Chronological digest date, page, topic, topical digest topic, page, summary. 14-4G interrogatories. A, prepare a list of the interrogatories to be sent. This is done after reading everything in the file to date. For example, complaint answer, interview reports, investigation reports, and deposition transcript if available. B, work with the client in preparing a draft of answers to interrogatories received from the other side. C, enter due dates and office tickler to serve as reminders of the dates interrogatories must be sent and must be answered. D, prepare the privilege log in order to have a list of what is not discovered. C. Enter due dates and office ticklers to serve as reminders of the dates interrogatories must be sent and must be answered. D. Prepare the privilege log in order to have a list of what is not discoverable by the other side through interrogatories. E. Draft a motion to compel a response to interrogatories if responses are improper or inadequate. F. Prepare an index of the answers to the interrogatories. The index should include an alphabetical list of all major topics covered in the ROGs, also known as in the interrogatories. G. Digest, summarize the interrogatory answers. See Exhibit 14-12 for different ways to prepare digests. H. Compare the interrogatory answers with deposition testimony, identify patterns, look for inconsistencies, etc. 14-4H, request for admissions. A. Read everything in the file to date, like for example, complaint answer, interview reports, investigation reports, interrogatory answers, deposition transcript in order to prepare a list of facts or legal conclusions. The other side will be requested to admit or accept. B. Index and digest the responses from the other side. C. Enter due dates and office tickler. D. Prepare the privilege log in order to have a list of what is not discoverable by the other side by using an RFA. 14-4I, production of documents and things. A. Prepare a draft of a request for production of electronic data, paper documents, or other things. Specify what you want to copy, inspect, or test, and when you want to do so. B. Arrange who will do the inspecting, copying, paying, costs involved, etc. C. Draft a motion to compel the inspection, copying if necessary. D. Index and digest the reports based on the inspection, copying, etc. E. Enter scheduled dates for inspection and copying in the office tickler. F. Prepare the privilege log in order to have a list of what is not discoverable by the other side in a RFP. 14-4J, request for independent medical examination. A. Prepare court motion to order the examination. B. Schedule appointment and payment of doctor or other professional who will conduct the examination. C. Enter dates pertaining to the examination in office tickler. D. Prepare court motion to have matters relevant to the examination be deemed admitted for failure to submit to the examination. 14-4K, the duty to supplement the discovery. Under the Federal Rules of Civil Procedure, Rule 26E1, the parties have a continuing duty to supplement any discovery submitting between the parties during the course of litigation. The parties have a continuing duty to supplement any discovery submitting between the parties during the course of litigation. What this means is that even after you submit your client's responses to discovery as required, if anything changes or new information is discovered, you are under a duty to amend the initial response. Otherwise, it is highly likely that the information will later be challenged by the adverse party, resulting in possible sanctions or not being able to use that information in the case altogether. Recall our case study earlier in the chapter, Lamb vs. Outback Steakhouse. That was one of the issues that was raised in the case. As a paralegal, it may be your job to keep track of the information that is discovered during the pendency of a lawsuit and follow the procedures for notifying the opposing party of the additional material. This is why keeping discovery logs is critical in a case. It is not simply what is produced in response to a discovery request, it also is what is discovered after that response is due. That is just as important as timely exchanges of discovery between the parties. Thus, always keep the duty to supplement discovery requests as a priority and tickle the case at various intervals to assure that the duty is fulfilled. If required in your jurisdiction, quick tip, not all jurisdictions have a continuing duty to supplement discovery. Always verify the requirements in the jurisdiction where the lawsuit is filed. Digesting discovery transcripts and documents. A discovery task that some paralegals frequently perform is digesting or summarizing transcripts and documents, particularly depositions. This is a labor-intensive task, but one that is important. Litigation paralegals can spend a good deal of time digesting. Occasionally, you will see a want ad for paralegals to digest depositions full-time. Such individuals are sometimes called depo summarizers. While all litigation paralegals do not perform the task full-time, it is a task that is often time. When all litigation paralegals do not perform the task full-time, it is a task that is oftentimes performed by a paralegal. Before digesting can occur, every page of a discovery document may have to be sequentially numbered. Your digest will refer to specific page numbers in these documents. You will be inserting the page numbers. A variety of numbering formats are possible, like for example 1, 2, 3, 4, 0001, 0002, 0003, 0004, or ABC1, or ABC2, ABC3, ABC4. You can combine names with numbers. The pages of the Jackson deposition, for example, might be numbered Jackson 01, Jackson 02, Jackson 03, Jackson 04, and so on. Page numbering is often performed with a desk tool called a Bates stamp. Each time a page number is stamped using this tool, the number on the tool automatically advances so that the next page will be stamped with the next number. Whoever is inserting or stamping the page numbers does not have to advance the number on the Bates stamp manually. Numbering pages with this tool is referred to as Bates numbering. If the document being digested is an electronic or digital document, like for example a PDF file, it can be sequentially numbered by using special Bates stamping software. An Adobe product such as Acrobat is an example of software that can insert page numbers on PDF documents. Virtually all offices now have an electronic form of Bates stamping, with many copiers having that feature. At depositions and in court proceedings, a reporter is present to record everything that is said and to certify that the recording is accurate. The attorneys then purchase a transcript, a word-for-word account of the deposition, questions, and answers from the chapter. The attorneys then purchase a transcript, a word-for-word account of the deposition, questions, and answers from the reporter. To qualify as a reporter, an individual may be required to write at a speed of up to 225 words per minute with over 95% accuracy. The reporter works with a computer and a stenotype machine that uses its own form of shorthand. Software in the computer translates the data into English. Reporters are able to make the transcript available on a disk so that the law office can immediately load the deposition directly into their litigation software. Other formats for court reporting include digital audio and digital video recording. Real-time transcription, whereby a draft of the transcript is made available to the attorneys on computer screens while the witness is being questioned, is also possible. Once the law office receives the transcript of the deposition from the reporter on paper or in digital format, paralegals are often asked to summarize it. 3 major kinds of digests can be prepared: page, line, chronological, and topical. A page-line digest is a summary of a deposition transcript that presents the questions and the deponent's answers in the order in which the questions were asked, along with the page and line numbers where the questions and answers appear. The lines on every page of the transcript are numbered sequentially, with the first line of each page being number 1. A chronological digest is a summary of a deposition transcript that presents the events described in the deponent's answers in their chronological order. Finally, a topical digest is a summary of a deposition transcript organized by specific topics covered in the answers of the deponent. For example of these different styles of digests, see Exhibit 14-12. As a rule of thumb, every 10 pages of a deposition can be digested into one page. The 10 to 1 ratio, of course, is not absolute. The length of the digest depends on what the supervisor wants summarized and on the complexity of the testimony being summarized. Many software programs are available to facilitate the creation of deposition digests. This technology is often part of a case or litigation management system. Check with your supervisor to determine what is available in your law firm or company. Of course, depositions are not the only discovery documents a paralegal may be asked to summarize. Answers to interrogatories, medical reports, on-site inspection reports, and responses to requests for admission can also be summarized. A paralegal may be asked to examine all of these documents to summarize specific topics, to look for inconsistencies, or to identify gaps in information that could require further discovery or investigation. Exhibit 14-13 provides general guidelines for all these digesting tasks. Exhibit 14-13 Guidelines for digesting discovery documents. Obtain clear instructions from your supervisor. What precisely have you been asked to do? What kind of digest is required? What have you expressly or by implication been told not to do? How much time do you have to complete the digest? To what case will your time be billed? Write down the supervisor's instructions. If you have never worked with a particular supervisor before, show them your work soon after you begin the assignment to make sure you have understood the instructions. Find out if the law firm has an office manual that gives instructions on digesting. If not, check closed files for samples of the kind of digesting that the firm has done in the past. Ask your supervisor if you should use such samples as models. Keep a list or know where to find a list of every document in a file. Some digesting assignments will require you to examine everything in the file. Know the difference between paraphrasing testimony and quoting testimony. To paraphrase is to phrase the testimony partly or entirely in your own words. To quote is to use the exact words of the witness, even though you may leave out part of what the witness said. For many digesting assignments, you will be asked to quote, not paraphrase. Use ellipsis, dots, ... to indicate that you left something out of a quote. Assume, for example, that the full sentence says, Jones is 24 years old and works at Telco. A summary with ellipsis dots indicating that you left something out of the quote might read, Jones ... works at Telco. Do not editorialize. Important example, inject your personal comments unless your supervisor asks you for such comments. For example, do not say that the response of a witness whose testimony you are digesting is unbelievable. Know the case inside and out so you can grasp the context of what you are digesting. You cannot digest something you do not understand. Read the client file, including interview and investigation reports, pleadings, interrogatory answers, other discovery documents, and etc. Each summary should include the specific document you used, like for example the March 13, 2023 deposition of Ann Davis, MD, and the page numbers that you summarized. The page line digest should also include line numbers. The answers given in a deposition often ramble. The same may be true of some interrogatory answers. Therefore, act on the assumption that the same topic is covered in more than one place in the discovery document. Look for this diversity and record it in your summary by pointing out each time the same topic is mentioned. Do not expect the answers to be consistent, even from the same witness. Do not consciously or unconsciously help the witness by blocking out potential inconsistencies. If on page 45 the witness said they saw a car, but on page 104 said they saw a van. Do not block out the distinction by saying they saw a motor vehicle or by failing to mention both. The danger of doing this is more serious than you think, particularly when you are reading hundreds of pages and are getting a little red in the eyes. When doing topical digests, think of the categories of facts that would be most useful for the attorney. The categories may be as broad as the name of a given witness. More precise examples of categories include background information, education, past employment, present employment, medical history, insurance, prior claims, pre-accident facts, accident facts, post-accident facts, medical injuries from this accident, damage to property, prior statements made. Update the summaries after you finish your digest. More facts may become known through further investigation and discovery. Ask your supervisor if you should add these facts to your earlier summary reports. Outsourcing. In large cases, some law firms will outsource digesting tasks to third parties, such as contract legal professionals, companies, and staffing agencies. This is used as a cost and time efficiency measure. However, as noted in Chapter 6, there are ethical concerns that must be considered when using outsourcing, as concerns over the disclosure of confidential information is real. However, as noted in Chapter 6, there are ethical concerns that must be considered when using outsourcing, as concerns over the disclosure of confidential information is real. As a way to address ethical concerns over outsourcing, any work outsourced should be properly supervised, reasonably priced, conflict of interest free, and when necessary approved by the client. Big data and predictive coding. We live in an era of big data, which are vast quantities of information collected by commercial and government computers. When law firms are engaged in litigation that involves big data, they often hire IT, information technology, consulting firms to capture, transfer, store, visualize, and analyze the data. The trend in such large cases is to use predictive coding to find relevant documents in vast databases. Predictive coding, also referred to as technology-assisted review, consists of computer programs that search for documents that are relevant to a case. After documents are loaded into the program, a lawyer manually reviews a batch of the documents to train the program how to recognize what is relevant to a case. The manual review is repeated until the program has developed a model that can accurately predict the relevance in the rest of the documents. 5. Trial notebooks. A trial notebook is a collection of documents, arguments, and strategies that an attorney plans to use during a trial. It is often organized in a loose leaf binder with tabbed sections for easy use by the attorney, or is prepared electronically. See Exhibit 14-14. How the notebook is prepared and the form it takes is purely the preference of the attorney. The notebook becomes the attorney's checklist for conducting the trial. The contents of the notebook are not submitted to anyone outside the law office. Exhibit 14-14, example of a trial notebook. Source: Binder Tech, Amherst, MA. www.bindertech.com. Jury panel chart, case notes. A 3-ring binder with dividers. Not all trial notebooks are organized the same way. Litigation assistant Pam Robtoy cautions us that just as each attorney has different preferences on how they want you to perform different tasks, each notebook you organize will be different depending on which attorney will be utilizing the notebook and the particular requirements of the case. For example, a trial notebook for a medical malpractice case would likely contain a section for medical research regarding the surgical procedure, medication, etc. That is the focus of the case. A trial notebook for a breach of contract case would not. A comprehensive trial notebook might contain the following sections: table of contents of the trial notebook, to-do list, trial schedule and deadlines, trial team, street addresses, phone numbers, email addresses, case outline, statement of facts, pleadings, trial briefs, trial memoranda outlining the facts and law of the case, law relied on for causes of action, defenses, and admissibility of evidence, outline of liability, PDF copy of email posts, our exhibits, oppositions exhibits, our witnesses, oppositions witnesses, witness statements, requests for production, responses to requests for production of documents, requests for admission, responses to requests for admissions, direct examination outline of questions, anticipated cross-examination questions, outline of damages, evidence to offer as foundation for admissibility, motions, deposition summaries, voir dire questions, juror information, jury chart, records, opening statements, plaintiff testimony, requests for jury instructions, defendant testimony, closing arguments, settlement proposals, evidence log, see Chapter 11, privilege log. It's often the paralegal's job to collect the material that will go into the notebook, organize it, keep it current, and help make it useful to the attorney as a vehicle for trial preparation and management. Specifically, the paralegal might do the following: prepare summaries of deposition testimony, prepare a list of all properties and witnesses, plus people who are expected to be mentioned during testimony, index this list to the rest of the trial notebook, prepare sample questions to ask witnesses, particularly when needed to lay the foundation for evidence to be introduced, prepare a summary description or log of all the exhibits to be used, prepare an abstract, brief summary of the contents of every document, state the location of relevant documents and exhibits that will not be contained in the trial notebook itself, cross-index material on particular witnesses or on legal theories, summarize all information known about each juror from voir dire, prepare end tabs for each section of the notebook, color code different kinds of documents and information. Examples: blue sheets for citations to authorities that support claims, yellow sheets for deposition testimony and other statements of the opposing party, etc. Again, you need to adapt these tasks to the particular needs of your supervisor. One paralegal color-coded all the tabs: green for exhibits, orange for discovery, data, etc. Our paralegal color-coded all the tabs: green for exhibits, orange for discovery, data, and etc. Before she discovered that the attorney using the trial notebook was colorblind. Before she discovered that the attorney using the trial notebook was colorblind. The paralegal's trial survival tools. Being in trial with your trial team is labor-intensive, exhausting, and exhilarating all at the same time. An effective paralegal is ready for anything and essentially should prepare a mobile office when in trial. An effective paralegal is ready for anything and essentially should prepare a mobile office while in trial. Many paralegals pack a small roller board case with essentials that may be needed during trial. Items to include in your trial survival kit are writing instruments, highlighters, Sharpies, Post-it notes, paper clips, stapler with extra staples, scissors, extra notepads and folders, exhibit stickers, Scotch tape, and any other office supplies. Also, think of the needs of the trial team as well. Include in your survival kit aspirin, Tylenol, antacids, medications, mints, energy or granola bars, chocolate, or any other snacks that will help the team going in the event. Lunch include in your survival kit aspirin, Tylenol, antacids, medications, mints, energy or granola bars, chocolate, or any other snacks that will keep the team going in the event lunch is missed or when everyone is working through lunch. Some practical supplies to consider including are extra or external batteries for electronics, extension cords, smartphone chargers, pointers and exhibits, or any other item that may be needed to the trial team. Every survival kit for trial is different and may change depending on the case and the team itself. Communicate with your trial team members to determine what is necessary for your survival kit, and then think outside the box. A trial survival kit is what works for you and your team. There is no right or wrong way to do it. What to include in your trial survival kit may be trial and error. Another important trial survival tool is you. Take care of yourself during trial by getting enough sleep and nourishment. Preparing and participating in a trial is long hours, and you must remember that you need to be at your best. When there is a break, try and get some fresh air or take a walk for a few minutes to rejuvenate yourself. Remember, you are a critical member of the team and use whatever survival tools you need to be successful during the trial process. 6. Settlement. Throughout the pre-trial stage of litigation, the opposing attorneys often engage in efforts to negotiate a settlement of the case in order to avoid a trial. One of the formal documents the parties sometimes use during negotiations is the settlement workup, also called a settlement brochure. It contains a summary of the major facts in the case presented in a manner designed to encourage the other side or its liability insurance company to settle the case. Paralegals often have a large role in helping draft this document. For a memorandum on a settlement workup, see Chapter 13. 7. Expert witness. Paralegals may have different tasks in working with expert witnesses that the trial attorney may want to use. The first task is to locate potential experts for consideration. Many can be located online. A paralegal can use free and paid websites to locate specific kinds of experts. If, for example, the office has a products liability case, such as the one discussed with our client, Mr. Elason, in Chapter 12 and 13, which involved allegedly defective airbags on a 2014 Honda Pilot. It is often relatively easy to use online resources to find experts who have testified in the past on this defect or on a closely related defect. Once you find such an expert, the next step is to use online resources to check that expert's credentials and to obtain recommendations by contacting law offices that have used the expert on their cases. Once an expert is selected, your office sends a formal engagement letter. An engagement letter for an expert may include confirmation about hiring the expert, a summary of the case, including the case name and docket number, if the case has already been filed in court, anticipated dates for the expert's testimony and deposition, at trial, or both, the scope of the expert testimony to be provided, a formal copy of the expert's curriculum vitae, CV, or resume to be used at trial, a possible list of articles or documents enclosed with the letter that the expert should review, names of the primary contacts in the office that the expert should use, such as the supervising attorney and paralegal, a summary of the financial terms for hiring the expert, any other pertinent information that is required for that specific engagement. After experts are hired, the paralegal may be asked to monitor the ongoing relationship with them. This often includes keeping a detailed log on everything sent to the expert for review. The log will note what was sent, like for example memos, scientific studies, exhibits, and fee payment checks. The format used for communication, like for example email, paper, and the dates these items were sent. The log will note what was sent, like for example, memos, scientific studies, exhibits, and fee payment checks. The format used for the communication, like for example, email, paper, and the dates these items were sent. To summarize, generally, a paralegal performs many of the pretrial tasks in a civil case. They range from assisting with the preparation, drafting, and filing the complaint, serving the complaint on a defendant, gathering client information, and investigating witnesses, preparing discovery requests and responses and motions, summarizing depositions, assembling a trial notebook, creating trial exhibits, preparing and finding expert witnesses, drafting of voir dire questions, and performing permitted background research on potential jurors, preparing a trial survival kit. 14-5 Litigation Support. The trial stage, an invaluable team member. The role of paralegals at trial depends in part on the involvement they have had with the case up to trial. If the involvement has been minimal, they will probably have either no role or a minimal role during the trial. Once the attorney is in court conducting the trial, most paralegals are working on other cases. If, on the other hand, a paralegal has been working closely with the attorney on the case all along, the paralegal might be given tasks during the trial. A paralegal's trial tasks might include visiting the court in advance of the trial to determine the location of the following items within the courthouse itself and within walking distance of the courthouse building. Points from which online access can be obtained: telephones, photocopy machines, fax machines, food takeout facilities, vending machines, stationery supply stores, public restrooms, etc. If the trial will be out of town, the paralegal might be asked to set up a secure hotel conference room, sometimes called a war room, where the litigation team can regularly meet between trial sessions, monitoring all the files, documents, and evidence needed by the attorney to plan and replan a strategy as outlined in the trial notebook, obtaining copies of laws needed by the attorney or doing spot legal research online or in available volumes on issues that come up during the trial that require a quick answer, preparing preliminary drafts of certain motions and other documents that are required during the course of the trial, coordinating the scheduling of witnesses and assuring the presence of witnesses, assisting the attorney in preparing them for direct examination and in coordinating the scheduling of witnesses and assuring the presence of witnesses, assisting the attorney in preparing them for direct examination and in anticipating questions that might be asked of them on cross-examination. Using a laptop or tablet, take notes during the trial, specifically on the testimony of witnesses or judges' rulings. The attorney may be able to use these notes in preparing for other segments of the trial, like for example, closing argument. A transcript, typed or digital, of the testimony from the court reporter may not be available until after the trial. Comparing witnesses' trial testimony with what was said during discovery, such as in a deposition, and informing the attorney of any inconsistencies. Monitoring the reactions of the jury as the trial unfolds. For example, if juror number 7 lights up when the attorney makes a certain point, or if juror number 10 does not appear to be paying attention, the paralegal will let the attorney know about these reactions during a recess or at the end of the day, so that the attorney can decide if anything should be emphasized or if a different strategy is needed when the trial resumes. Making suggestions to the attorney on what questions to ask a witness based on what was happened. Making suggestions to the attorney on what questions to ask a witness based on what has happened thus far in the trial and based on the paralegal's involvement with the documents and files prepared during the trial stage, assisting with trial exhibits and documents, visiting the courtroom to determine the electronic capabilities, performing any other tasks needed by the attorney conducting the trial. Technology update: the digital courtroom. Gone are the days when paper and paper exhibits are the norm. Many of today's courtrooms are equipped with the latest technology and gadgets, things that both the paralegal and attorney need to know how to use. With budgets a bit more generous, the federal courts are more likely to be fully digitized compared to many state courts. For the paralegal, it is important to know what your courts have, from the type of equipment installed to knowing where to access an outlet. If preparing a hearing or trial, make it a priority to visit the courtroom to determine what's there. Most courtrooms have a state-of-the-art sound system, teleconferencing, real-time court reporter transcript distribution, as well as other technology advances. For example, the court has the ability to control audio, masking, or muting sidebar conferences by the attorney so the jury cannot hear the discussions with the judge. Note that the audio and visual systems are controlled by the judge and courtroom staff, although the parties and attorneys can control how they display evidence. Judges ultimately control the entire proceeding by the flip of a switch. This is known as the kill switch. A judge can immediately shut down courtroom monitors, which blanks out the screens for the jury, witnesses, and public galleries. There can be a myriad of reasons for a judge's use of a kill switch, such as determining the admissibility of evidence, but know that the switch is there and readily available for use. Additionally, some courtrooms are now equipped with electronic evidence presentation systems, EEPS, which include dedicated evidence presentation monitors, flat screens for viewing evidence from the public galleries, and video inputs. This new technology permits attorneys to use laptops to display evidence on monitors for both the witnesses and jurors. Courts often provide instructions on how to use the EEPS, which, if you are working on a case where the court does have EEPS, are encouraged to review and master. There are many attorneys who are either technology challenged, too busy to learn, or do not have any interest in learning the technology. It is incumbent upon the paralegal to be prepared to assist when technology overtakes the presentation. It's an opportunity for the litigation paralegal to exhibit those qualities discussed throughout this text. You prepared paralegal. When preparing to work in a digital courtroom, be sure everything is properly loaded onto the laptop, tablet, or portable device that is intended to be used at trial. Have a backup plan just in case there are technical difficulties, and oftentimes there are. Have a plan B and plan C, which may include paper backup if there is a technology failure. Importantly, what is used in the federal courts is more likely not the system used in state courts. Do not assume what is used in one courtroom will be used in another. Some courts provide guides to using the courtroom technology and the rules associated with the use of the technology in that courtroom, which can be found on the court's website. Know who to contact for questions about the technology in the courtroom you will be in, and seek permission if bringing in your own electronic equipment. In closing, know your courtroom and what is available. Prior to a hearing or trial, check for 1. Available outlets, 2. Laptop inputs for internet connections, 3. Available displays such as monitors and flat screens, 4. Video conferencing capabilities, and 5. Any other technology needs to address with the court. Learn what's available and master the courtroom technology. It will be an indispensable skill that will show your ingenuity. Learn what's available and master the courtroom technology. It will be an indispensable skill that will show your ingenuity as valued member of. Learn what's available and master the courtroom technology. It will be an indispensable skill that will show your ingenuity as a valued member of the litigation team. 14-5A exhibits. Trial exhibits can include photographs, x-rays, medical illustrations, video presentations, anatomical models, surgical appliances, computer reenactments, etc. Some paralegals are able to design exhibits that will be used at the trial. Exhibits that contain a timeline of the significant events can be helpful for jurors to visualize the impact of crucial facts, such as a timeline of an accident with a minute-by-minute graphic. Some examples of paralegal work creating trial exhibits. In a case brought against Walmart, paralegal Susan Sharp designed a 5-foot-long by 3.5-foot-tall poster board filled with 1/16 of an inch squares, each representing $1 million, to graphically illustrate Walmart's wealth. The poster board was used by the trial attorney during the damages stage of the trial. Paralegal Catherine Astle created a medical treatment calendar chart. We painstakingly thumbed through literally stacks of records, making a list of all therapy visits, doctor visits, pain injection procedures, and hospitalizations. We then color-coded these events, such as all therapy visits color-blocked in blue, all hospitalizations in green, etc. We then gave this information to our exhibit vendor, where they shaded in each appropriate box, each of which represented a day on the calendar for the particular event. For example, if March 4th through 8th was a hospitalization event, those days were shaded in green. When completed, the jury could visually see the amount of greens or hospitalizations over several years, the number of blues spent in therapy, the amount of time spent in doctor offices, and the total number of days this poor soul spent in agony after a treatment. Different versions of the chart, created by Catherine Astle, are often used as exhibits in personal injury cases. One of the most popular is the Life Activity Calendar, that presents a day in the life video or chart on the plaintiff. The exhibit carefully catalogs the minute-by-minute activities of the plaintiff in order to help demonstrate the impact of the injury. In the office, if the office hires a litigation consultant to create such graphics, the role of the paralegal might be to help monitor the work of the consultant. If the office hires a litigation consultant to create such graphics, the role of the paralegal might be to help monitor the work of the consultant. Computer graphics presentation programs such as Microsoft's PowerPoint are available to help create graphics. They can generate slides that contain text, pictures, drawings, and maps. PowerPoint also allows videos or movies to be integrated into the presentation. For more on these computer programs, see Chapter 11. Displaying trial exhibits often requires the use of computers, overhead projectors, video players, magnetic boards, blackboards, chart holders, and the like. The judge's permission is needed to bring such devices into the courtroom if they are not already present. Permission is usually sought through the judge's clerk, secretary, or other court personnel. Additionally, paralegals will track each exhibit presented in a trial. This is an important task as it assists the attorney in knowing which exhibits were admitted into evidence and which exhibits were not. Make a chart that is easily referenced, tracking the exhibits presented. Note in the chart whether there were objections to the exhibit and how the judge responded. Another task to track at trial is the presentation of exhibits and through which events. Follow closely each witness and the exhibits that the attorney was intending to enter through that witness, making sure the attorney does not miss an exhibit for presentation at trial. 14-5B, mock trials and shadow jurors. If the office is about to begin an important and potentially complex trial, it may decide to conduct a mock trial to give the participants stand-up practice and feedback. A mock trial is a pretend trial staged by one side to operate as close as possible to the upcoming real trial. The office can hire strangers to play the role of jurors. Attorneys in the office will play the role of opposing counsel. Paralegals and secretaries might be asked to play the role of witnesses. After each side presents its case, the juror renders its verdict and makes itself available to critique the strength of the evidence and the performance of the attorneys. This can be very helpful to the attorney who will be trying the case. The exercise is the equivalent of assembling a focus group to obtain reactions to a product or presentation. Another option is to use shadow jurors. These are persons hired by one side to observe a trial as members of the general audience. Typically, a law firm will use a jury consultant to select citizens as close demographically. Typically, a law firm will use a jury consultant to select citizens as close demographically to the actual jury as possible, like for example, race, occupation, and income level. Typically, a law firm will use a jury consultant to select citizens as close demographically, like for example, race, occupation, and income level to the actual jury as possible. During recess and at the end of the day, these jurors will tell the consultant what they thought of the physical evidence and witnesses and the performance of the trial attorneys. The consultant will give this information to the attorneys who hired the consultant and shadow jurors. Based on this feedback, the attorney will decide whether any shift in trial strategy is warranted for the remainder of the trial. Paralegals might be used to help coordinate the work of the jury consultant as the trial progresses. 14-6 Litigation Support the criminal litigation process. The civil and criminal trial processes have many similarities, and yet there are some stark contrasts. Depending on which side you are on, the activities in a criminal case differ. If you work for a prosecutor's office, preliminary tasks occur before a person is charged and arrested. Conversely, if you are on the defense side, you often do not begin working on a case until an arrest occurs. Thus, a paralegal who works for an office that prosecutes may work with the investigating authorities, such as the police departments, who determine whether there is enough evidence and information to bring a case, assist in preparing arrest warrants and probable cause affidavits, assist in reviewing the charging documents such as information, attend court with the prosecutor for the initial appearance of a defendant, gather all information required in discovery to relay to defendant's counsel, track all court hearings and pretrial conferences, arrange for meetings between the attorneys for possible plea bargains, assist in the preparation of trial, including preparing the trial notebooks and exhibits, research any legal issues, issue subpoenas for witnesses, prepare voir dire questions, and review potential jurors, including conducting permissible background checks, participate in trial and assist attorneys with witnesses, exhibits, and notes, assist in the preparation of jury instructions, perform any other tasks required by the prosecutor. The paralegal for the defendant will perform similar tasks as described above. However, defending a criminal prosecution has some different tasks. These tasks may include meeting with defendant and performing background investigation of charges, preparing a fact sheet for attorney in preparation of defendant's appearance for bail, drafting of motions or preparing of letters to prosecution for required evidence disclosures and discovery, preparing for arraignment and any other court appearances on defendant's behalf, preparing information for possible plea bargain negotiations, assisting in voir dire preparation and research, locating information that supports defendant's position, assisting in drafting motions for trial, such as motions in limine and motions for directed verdict, performing any other tasks required. As with civil trials, criminal trials are intensive and time-consuming. The preparation can be extraordinary with long hours on the job, knowing how the process works and how you can assist with that process makes for an invaluable member of the trial team. (14-7) Litigation support the appeal stage, gathering trial information. Once the trial is over, the central question becomes whether to appeal. The party bringing the appeal is the appellant. The party against whom the appeal is brought is the appellee. In some cases, both sides might decide to appeal if neither party obtained everything it wanted at the trial. As a result, the paralegal may be asked to draft the notice of appeal for review by the attorney, file the notice of appeal with the court, order the trial transcript for review of the record and identifying the issues on appeal. Attorneys must review all of the documents and transcripts from the trial in order to identify grounds for an appeal. A paralegal may be asked to go back over the record and do the following: find the page number in the record that supports a statement of fact that the attorney mentions in their appellate brief. Make a list of every time the trial attorney objected to do something during the trial. Include the page number where the objection is found, a brief summary of what the objection was, and the ruling of the judge on the objection. Make a list of every time opposing counsel referred to a particular topic, such as the plaintiff's prior involvement in other litigation. Make a list of every time the judge asked questions of witnesses. Summarize, digest trial testimony relevant to issues to be raised on appeal. This information can be critical when the attorney prepares the appellate brief. Arguments made in the brief must refer to the judge to specific parts of the trial record and transcript that are relevant to the arguments being made. These references to specific pages in the trial record are called record cites. The office must be scrupulous in ensuring that references to the record are accurate, particularly quotations from trial transcripts. Other important paralegal roles on the appellate brief are preparing the table of authorities and cite checking. The table of authorities, TOA, is a list of every primary authority, like for example cases and statutes, and secondary authority, like for example legal periodical articles and legal treatises, that a writer has cited in a document such as an appellate brief and indicates where they are mentioned in the document. For an excerpt from a table of authorities, see Chapter 10. In Chapter 11, we examine software used to help create these tables. The task of cite checking the appellate brief is performed by examining citations in a document to determine their accuracy, such as whether the format of the citation is correct, whether a parallel cite is needed, whether quoted material is accurately quoted, and whether the law cited is still valid. Has it been overruled, appealed, or otherwise modified? Recall this skill of cite checking was covered, included the use of major citators such as Shepard's and Key Cite in Chapter 9. Once the appellate brief is complete, paralegals can be asked to help monitor its printing in-house and through an outside printing vendor, filing in court, and service on the Once the appellate brief is complete, paralegals can be asked to help monitor its printing in-house or through an outside printing vendor, filing in court, and service on the opposing side. Quick tip: most appellate courts require hard copies of the briefs Most appellate courts require hard copies of the briefs and joint appendices to be filed with the court in addition to electronic filing. Check appellate rules, including local rules of that court, to determine whether hard copies must be filed physically with the court and the number of copies required. When an opponent's appellate brief is received by the office, like for example the reply brief, the paralegal might be asked to check the accuracy of all quotes to the record and to use the standard citators to determine whether any of the laws cited in the opponent's brief have been overruled, repealed, or otherwise modified. Some highly skilled paralegals are also given responsibility for drafting part of an appellate brief itself, particularly if the appeal involves an issue the office has often litigated in the past. For example, the appellate office of a public defender might often appeal search and seizure issues in criminal cases. A paralegal who works for such an office might be asked to locate earlier briefs on this issue in the office's brief bank and to adapt one to the facts of the particular case currently on appeal. Once the briefs are filed, the case may be set for oral argument. Once the briefs are filed, the case may be set for oral argument before the court. A paralegal may assist in working with the attorney who is preparing for oral argument. This may include a mock session of oral argument known as moot court by some. Colloquially, it is often said that you will moot the attorney. All that means is that the attorney will practice the potential arguments before a selected group of individuals, usually attorneys, former judges, and possibly the paralegal. After this preparation occurs, the attorney will then present the case before a panel of judges, usually a 3-person panel. The court will ask questions during the oral argument and ultimately render a decision on the matter. See Exhibit 14-7 for an overview of the appellate process. 14-8 Litigation supports the enforcement and collection stage, being a slew. If a money judgment was awarded to the client, considerable work may be required in collecting it from the judgment debtor, the party obligated by the court to pay the judgment. Unfortunately, collecting that judgment can be a difficult undertaking. An investigator or the paralegal may be asked to assist in ascertaining the financial assets of a particular individual or corporation against whom the judgment was obtained. The person who won the judgment and must be paid is the judgment creditor. If the judgment debtor refuses to pay the judgment, the paralegal for the judgment creditor can help arrange for the sheriff to begin execution. If the judgment debtor refuses to pay the judgment, the paralegal for the judgment creditor can help arrange for the sheriff to begin execution, which is the process of carrying out or enforcing a judgment. Finding a debtor's assets is not always easy. However, one of the best starting points for such an investigation is government records. The following is a partial list of records available from the county clerk or court office. Real property records. Check grantee and grantor indexes. Real and personal property tax assessments. Filings made under the Uniform Commercial Code, UCC. Federal tax liens. Court dockets to determine whether the judgment debtor has been a plaintiff or defendant in prior litigation. Check the abstract of judgment index. Inheritance records to determine whether the judgment debtor has inherited money or other property, determined by checking records of the surrogate's court or probate court, which handles inheritance and trust cases. Any of these records could reveal a good deal of information on the financial status of people from whom you are attempting to collect a judgment. You might find out whether they own or have an interest in valuable personal or business property. Even though tax records often undervalue the property being taxed, there are some indications of a person's wealth. For corporations that are judgment debtors, check the records of state and federal government agencies such as the Secretary of State and the Federal Securities and Exchange Commission, SEC, with whom the corporation must file periodic reports or disclosures on its activities and finances. You should also check with people who have done business with the corporation, customers or other creditors, as well as with competitors in the field. These records and contacts could provide leads. In addition to locating assets through public records, another avenue a paralegal may be tasked to perform is arranging for a post-judgment deposition. In this instance, the judgment debtor may be ordered by the judge to submit to an examination about their assets. This examination is an example of a post-trial deposition designed to help enforce a judgment. As the paralegal in the case, you may be asked to arrange for the time and place of the deposition and prepare the notice of deposition along with a subpoena ducis tecum. This process is similar to the one previously discussed in the chapter. If the judgment debtor fails to appear or is uncooperative in the post-judgment process, in some cases, the attorney may be able to petition the courts for a finding of contempt against the judgment debtor for non-compliance with court orders. The paralegal can help by assembling the factual basis to support this charge and drafting some of the court papers involved. And finally, a great deal of this information is now online so that it can be searched online. Some of the major databases and libraries are available on Westlaw and LexisNexis, the two largest fee-based online commercial research services. Even if you do not have access to these services, reading the following overview in Exhibit 14-15 will give you a good idea of the kinds of data that law firms try to obtain. The data are valuable when conducting due diligence investigations, such as when you need to verify the information given by a prospective business associate. Exhibit 14-15, examples of financial data on fee-based databases, Westlaw and LexisNexis. Due diligence searches on Westlaw, Asset Locator, ASSET, identifies real property tax assessor records, real property transaction records, pre-foreclosure records, unclaimed property records, aircraft records, watercraft records, and corporation stock records. Executive affiliation records, EAALL, provides name, title, business address, and phone number of millions of executives nationwide. Uniform Commercial Code, UCC, provides information on UCC filings, which can include debtor names and addresses, filing numbers, dates of filing, secured parties and assignees' status, filing locations, collateral, filing histories, and tax liens. Dun and Bradstreet business records plus DUNBR. Dun and Bradstreet business records plus DUNBR provides information on a company's history, operations, and financial performance, as well as intra-company relationships for millions of companies worldwide. Combined Corporate and Business Registration Records, CORP-ALL, provides abstract of business addressees, officers, directors, and partners, and location of registered agents. Bankruptcy Filings, BKR-ALL, provides summaries, abstracts of filings in U.S. bankruptcy courts, includes business filings in all 50 states and personal filings in selected states. Lawsuits, LS, provides abstracts of civil lawsuits filed in selected state and local courts. Dow Jones, All Plus Wires, All News Plus, provides business news reports from newspapers, magazines, journals, newsletters, government press releases, transcripts of television shows, radio shows, congressional testimony, and news wires, due diligence searches on LexisNexis, assets, deeds, all own, provides leads to the location and assessed value of corporate and individual real estate, hidden assets, parties and witnesses, and current tax mailing addresses for service of process. Also assesses the collectability of judgments and locates personal property. Also assesses the collectability of judgments and locates property for judgment lien attachment. Bankruptcy, INSOLV, and ALLBKT provides business and consumer bankruptcy filings, background data on parties, witnesses, and judgment debtors, tracks business and consumer bankruptcies, and helps assess the collectability of potential judgments. Business filings, INCORP, provides access to state and local business filings, including corporate registrations, limited partnership registrations, limited liability company registrations, county DBA doing business as filings, and professional licenses. Business reports, BUSRPT, provides business reports from Dun & Bradstreet and Experian that will help establish a company's existence, assess financial performance, ascertain client solvency, and confirm company ownership for determining potential conflicts of interest. Courts, docket, provides information from civil and criminal court indexes and dockets from local and federal courts. Liens, ALLUCC, ALLIEN, provides information on Uniform Commercial Code, UCC, liens, state and federal tax liens, and judgment from state courts. The data contain debtor names, addresses, secured parties, assignees, and types of pledged collateral. License, LICNSE, provides information on professional licenses, liquor licenses, driver licenses, pilots, tax practitioners, etc. This information helps locate self-employed individuals, verify their license status, and locate their business assets. Personal property, P-PROP, provides information from registrations of boats, motor vehicles, and aircraft. Verdicts and settlements, ALLVER, provides information on civil verdicts and settlements from the databases of National Jury Verdict Review and AMP analysis. NTLREV, verdicts, settlement, and tactics. VERST, and medical litigation alert. MDALRT. Verdicts and settlements, ALLVER, provides information on civil verdicts and settlements from the databases of National Jury Verdict Review and AMP analysis. NTLREV, verdicts, settlement, and tactics. VERST, and medical litigation alert. MDALRT. In the enforcement stage, a paralegal may perform several tasks, including such things as post-trial discovery, such as preparing a deposition notice in aid of enforcement, or post-trial interrogatories, set the time and place of a deposition, and arrange for the court reporter services, investigation of assets of the judgment debtor, arrange for execution of the judgment through a sheriff's office or equivalent authority in your state, real-world perspectives on the job observations. Our paralegal perspectives range from paralegals that work in collections and environmental law, as well as a paralegal that works in the courts. Their recollections show the success that each paralegal experienced while working in the respective field. We first hear from a paralegal working in the collections arena. I currently have responsibility for some 400 collection cases. My days are spent on the phone talking to debtors, drafting the necessary pleadings, executing forms, and hopefully depositing the money collected. The exciting part of collection is executing on a judgment. We were successful in garnishing an insurance company's account for some $80,000 when they refused to pay a judgment that had been taken against them. We have also gone with the sheriff to a beer distributorship. 2 days before St. Patrick's Day to change the locks on the building that housed gallons and gallons of green beer. The debtor suddenly found a large sum of money to pay us so that we would release the beer in time for St. Patrick's Day. R. Swogum, Collections Paralegal, the Citator 9, Paralegal Association of Central Ohio. In our next Paralegal Perspectives, we learn how a paralegal was able to successfully assist in proving an environmental hazard. The paralegal highlights the process of discovering evidence to support the case against a pollutant. Mary Peterson's firm has made a specialty of environmental and land use law. In a major hazardous waste case, we will try to prove that the paint companies, dry cleaning stores, and even the federal government, which used the property to build aircraft during the war, are responsible. Some of the toxic waste dumped there was cited by federal agencies even back to 1935. Her job is to investigate the types of hazardous waste and, with the help of the Freedom of Information Act, gather all available evidence. Then she studies it, duplicates, indexes, and writes summaries, which she distributes to the partners and associates. It's a case that has taken 8 months so far and may go on for several years, because you don't know what you will uncover tomorrow. The toxins and pollutants could be different. There is no standard, just a constantly changing picture. Edwards, the general practice paralegal, 8 legal assistant today, 49. And our last paralegal perspective is from someone who worked with the courts. The paralegal shows us how the rules we learned are applied and how the work is critical to assisting the judge or clerk in their ongoing cases. The Shreveport City Court has employed me as its paralegal in the civil department for the past 6 years. The Baton Rouge City Court employs several paralegals. We handle many matters, such as determining if the legal delays for pleading have expired before initialing the pleading and passing it on to the clerk or judge for signature. The most important task is the handling of default judgments. I must certify that proper service has been made. Perhaps I could be called a nitpicker about these cases, but the judge acts on my certificate that everything is in order. It is always challenging to stay informed on our constantly changing procedural laws. I must keep a set of the civil procedure laws at my desk. Waterman, the court's paralegal, 3 NWLPA News 5 Northwest Louisiana Paralegal Association. Chapter Review 14-9A. Chapter Summary. Overview of civil and criminal litigation and civil trial process. 1. Litigation is the formal process of resolving a legal dispute through the courts after a law firm is retained by the client. Civil litigation begins with the filing of a complaint, the service of process on the defendant, and the filing of a response answer by the defendant. In the complaint and the answer pleadings, the parties state their causes of action and defenses and tell the court what they want from the respective filings. 2. If the defendant does not respond to the complaint, the plaintiff can request a default judgment, which will end the lawsuit. If the defendant files a responsive pleading, such as an answer or motion to dismiss, the case will continue until the judge enters a judgment and ends the lawsuit. A defendant can file a countersuit against the plaintiff called a counterclaim. This is just one of the pleadings that can be filed by the parties in the lawsuit. 3. The next major event is discovery, which can include interrogatories, depositions, requests for admission, RFAs, requests for production, RFPs, and independent medical examinations, IMEs. All these kinds of discovery tools seek information from the parties to the lawsuit about their position and causes of action. If the parties believe that there are no genuine issues of material fact and they are entitled to judgment as a matter of law, a motion for summary judgment will be filed. Either party or both can file the motion. If motions for summary judgment are denied, the trial proceeds. 4. The trial stages commence with the picking of a jury if one is requested. If the trial is before a judge only, then no jury is chosen. After questioning the jurors as to their suitability to serve through voir dire, the jury is impaneled, and opening statements are made to the jury. The party with the burden of proof puts on its case through the introduction of evidence and the direct examination of witnesses. The latter can be cross-examined by the other party. No leading questions are generally permitted in direct examination. 5. When the party rests, the other goes through the same steps. A motion for a judgment as a matter of law, known as a motion for a direct verdict in some courts, may be presented and will be granted if there is no legally sufficient evidentiary basis for a reasonable jury to find for the party against whom the motion is made. 6. After closing statements to the jury and the instructions of the judge, the case goes to the jury. The jury examines and weighs the evidence and determines a verdict, who wins or loses. Its verdict, if accepted by the court, becomes the basis of the court's judgment. 7. If dissatisfied with the judgment, the losing party, usually the appellant, files a notice of appeal and an appellant brief. The appellee also files an appellate brief in response. After oral argument, the appellate court affirms, reverses, vacates, or otherwise modifies what the lower court has done. A further appeal to a higher appellate court might also be possible. Additional alternatives on appeal are filing a request for rehearing or a hearing en banc to the entire court. Criminal trial process. 1. Criminal litigation often begins with an arrest warrant, followed by an initial appearance. Once the decision on bail is made, the prosecution proceeds to the preliminary hearing to determine whether probable cause exists. If so, the grand jury will then determine whether to issue an indictment. Not all states have grand juries. 2. Discovery is different in a criminal trial process. The prosecutor must disclose all evidence that is collected regarding the defendant's guilt or innocence. Unlike civil discovery, the defendant does not have to formally ask for the evidence the prosecutor has a duty to disclose. 3. The arraignment is next, where the defendant is formally charged and enters a plea, usually not guilty, depending on the evidence against the defendant. A plea bargain may be offered, which permits the defendant to plead to a lesser charge and forego a trial. If plea bargaining is unsuccessful, the case goes to trial, where guilt must be established beyond a reasonable doubt. 4. The criminal trial then proceeds in a manner similar to a civil trial: voir dire, opening statements, presentation of witnesses and evidence, closing statements, and a verdict from the jury. The appeal process is also similar after a criminal conviction: notice of appeal, appellate briefs, argument, and decision by the court. Administrative disputes. 1. In an administrative hearing, a hearing examiner makes a decision on the dispute within the agency. Their decision will usually be in the form of a recommendation to a higher official or body within the agency. 2. That decision usually will provide findings of fact and conclusions of law upon which a higher authority can review the basis of the administrative decision. When a party has exhausted administrative remedies, an appeal of the agency's decision to another court is permitted. That appeal usually starts at a civil trial court acting as an appellate court of review. Alternative dispute resolution, ADR. 1. Alternatives to litigation, known as alternative dispute resolution, ADR, can include arbitration, mediation, med-arb, private judging, neutral evaluation, summary jury trial, summary bench trial, and collaborative law. Arbitration is a trial-like proceeding that is less formal than a court trial and less costly. It loosely follows a trial process with a decision rendered by the arbitrator who is acting like a judge. 2. Mediation is another form of ADR that parties can choose. In this setting, a mediator referees the issues between the parties in the hopes of bringing a resolution settlement. 3. Paralegals assist in the ADR process in a number of ways. They can outline the issues, summarize documents such as medical information and expenses, and arrange for the ADR session itself. In some instances, paralegals have become mediators or arbitrators. Litigation support. The role of the paralegal in the pretrial stage. 1. Among the roles fulfilled by paralegals during the pretrial stage of litigation are the following: drafting complaints and other pleadings, serving and filing documents, maintaining the calendar, preparing discovery requests, and digesting discovery transcripts and documents. When preparing documents, paralegals use standard forms that must be adapted for their particular case. Caution should be taken when using forms as they are meant to be adapted based on the law and facts of a case. Another place to use as a base for drafting documents is old cases, files, and brief banks. 2. In drafting a complaint, the basic components are caption, statement of jurisdiction, venue, body of the complaint, prayer for relief, jury demand, and signature block. Most complaints require a civil cover sheet. 3. The paralegal also assists with the service of process of the complaint. This is usually done through personal service. Most courts have electronic filing systems for filing a complaint and other related documents in the case. Any filed documents must be converted to a PDF document. 4. Another important task that paralegals perform is calendar control and scheduling of the case. This is usually done through a case management system where a matter is calendared with a due date. A tickler system is used which alerts the attorney and paralegal of an impending due date. This is a critical function for paralegals. 5. Discovery is another area that paralegals play a significant role in the pretrial process. Paralegals will draft the various forms of discovery: interrogatories, admissions, deposition notices, production of documents, and requests for medical examination. E-discovery is an important aspect of the discovery process where paralegals assist in gathering the electronically stored information and often assist in the preparation of a litigation hold letter. 6. After a deposition is taken, it must be reviewed and summarized. This is called digesting a deposition. There are 3 main methods to digest a deposition: page, line, chronological, or topical. The method used depends on the instructions of the attorney. 7. One of the last tasks a paralegal will perform in the pretrial stage is the preparation of the trial notebook. How a trial notebook is prepared is dependent upon the instructions of the supervising attorney. Most have similar components such as the pleading in the case, juror information, opening and closing statements, outline of witness testimony, including experts, list of exhibits, legal research, and jury instructions, and any other information that needs to be included. There may be a section regarding statement in the there may be a section regarding settlement in case the parties discuss that possibility at trial. Litigation support, trial stage. An invaluable team member. 1. As noted, the paralegal will assist in helping prepare the trial notebook, coordinating trial exhibits, and providing assistance as needed during the trial. During the trial, the paralegal will be available to monitor the files, assure the presence of witnesses, take notes, monitor the jury, assist with exhibits, and be alert as to what is going on in the courtroom. 2. Often paralegals will prepare exhibits and diagrams for the trial. As a result, the paralegal must be able to use the necessary equipment and know what is in the courtroom for use by the parties during trial. Litigation support, the appeal stage, gathering trial information. Once a trial is complete, the paralegal may assist in reviewing the record for appeal. This requires retrieving and digesting facts in preparation for appeal. If an appeal is filed, the paralegal assists with the preparation of the brief, particularly the table of contents and table of authorities. Other tasks may include cite checking, compliance with the rules, and actual filing of the brief with the court. Litigation supports the enforcement and collection stage, being a slew. Once a judgment is entered and final, the paralegal will begin the process of executing the judgment and finding ways to collect that judgment. The person from whom the judgment is collected is called the judgment debtor. It is not always an easy process to collect a judgment, so using sources online such as government sites, Westlaw, or LexisNexis are recommended. If a judgment debtor is uncooperative, a judgment creditor may request a deposition to inquire about their assets. If they do not cooperate, a court may issue a contempt order. Chapter Review 14-9B. Key terms: civil dispute, criminal dispute, estate, jointly and severely liable. Appearance, attorney of record, forum, venue, information and belief, prayer for relief, ad demum clause, subscription, verification, summons, process server, answer, defense, affirmative defense, contributory negligence, cross-claim, third-party complaint, adverse judgment, pretrial conference, scheduling order, court reporter, subpoena ducis tecum, summary judgment, motion in limine, bailiff, jury panel, voir dire, peremptory challenges, impaneled, rule on witness, sequester, sidebar conference, objection, direct examination, sustained, cross-examination, redirect examination, recross examination, expert witness, clerk, exhibit, rested, case in chief, judgment as a matter of law, directed verdict, judgment notwithstanding the verdict, JNOV, prima facie case, closing arguments, jury instructions, declaratory judgment, motion for a new trial, stay, bond, judgment on the merits, waived, rehearing, appeal by right, mandate, execution, warrant, prosecution, initial appearance, felony, misdemeanor, assigned counsel, bail, personal recognizance, preliminary hearing, bound over, grand jury, information, nolle prosequi, no contest, plea bargain, arraignment, acquitting, poll, double jeopardy, claimant, exhausted his administrative remedies, arbitration, judicial arbitration, contractual arbitration, award, mediation, med-arb, private, judging, neutral, evaluation, caption, notice pleading, special damages, fact pleading, substituted service, affidavit, evidence, depot summarizes, Depot summarizers, Bates stamp, page line digest, chronological digest, topical digest, shadow jurors, moot court, judgment debtor, judgment creditor, contempt. Chapter Review 14-9C, Review Questions. How does a lawsuit 1. How does a lawsuit begin, and what is the first document that is prepared to initiate the lawsuit? 2. What is service of process, and what are the methods used to effectuate service of process? What is substituted service? 3. Distinguish complaint, answer, counterclaim, cross-claim, and third-party complaint. 4. Name and define the major methods of discovery. 5. When will a court grant a motion for summary judgment, and when will a court grant a motion for summary judgment, and what must a litigant show in order for a court to grant a motion for summary judgment? 6. What is the distinction between a question of law and a question of fact, and how are they resolved? 7. What are the functions of the opening statement and closing argument? What is the sequence of the trial from voir dire to the verdict? What role does a paralegal play in preparation and during the trial? 8. Outline the appeals process. What are the different kinds of opinions that an appellate court can write? 9. In a criminal case, what happens at the initial appearance, preliminary hearing, and arraignment? What tasks does a paralegal perform in criminal litigation? 10. What is the function of an administrative hearing, and how does an administrative agency reach a final conclusion when it has a legal dispute with a citizen? 11. How does the major kinds of alternative dispute resolution ADR function, and what are some paralegal tasks in ADR? 12. What is a tickler system in a law office, and why is it important in the litigation process? What is redundancy, and how is it used in calendar control? 13. What is e-discovery? What kinds of e-evidence are often sought in e-discovery? 14. What is a deposition? Describe 3 styles of deposition digests. 15. What is a trial notebook and its components, and what roles can paralegals play in its preparation? Chapter Review 14-9D, Assignments, Critical Analysis 14.1. In large cases, there is often a great deal of digital data involved in discovery, search, predictive coding. Attorney, write a memorandum of law to your instructor in which you analyze the following topics. A. What is predictive coding and how is it used? B. To what extent does predictive coding mean a loss of jobs? To what extent does predictive coding mean a loss of jobs for attorneys and paralegals? Give citations to the authorities on which you rely in your answers. Projects. 14.2. The attorney for whom you work has just won a $1 million judgment against a defendant who is independently wealthy and is the sole owner of a company that makes cosmetics in your state. The defendant, however, claims to have no assets. Prepare a memo to your supervisor on the specific steps that can be used to find assets and collect the judgment in your state. Give citations that support the use of all of the steps you propose. 14.3. Assume that the judgment debtor is uncooperative. Prepare the notice of deposition and subpoena ducis tecum that would be sent by your office. Search online for examples of post-judgment discovery. Chapter Review 14-9E, Core Skills Assignments. Core Skill Writing 14.4. You are a paralegal working for Taylor Marcus of the offices of Windsor, Chan, and Marcus, LLC, who represents Adrian Smith. Rewrite Adrian's complaint in Exhibit 14-10 for your state. If the complaint could be filed in more than one state court in your state, select one of the courts. Check all relevant court rules and statutes available online for requirements on the format and content of complaints. Check all relevant court rules and statutes available online for requirements on the format and content of complaints. Your complaint should not include the labels or arrows to the left of the complaint in Exhibit 14-10. In your complaint, use the names provided: Adrian Smith, Fred Jones, and Taylor Marcus. You can make up any facts additional to those currently in Exhibit 14-10, so long as the added facts are reasonably consistent with the facts currently given in Exhibit 14-10. Attach a brief memo that lists the sources you used to prepare your complaint. Core skill research. 14.5. In this exercise, use your state administrative process for filing a workers' compensation claim to determine the steps to follow in filing an administrative complaint. The facts are: A. Ted Smith says that he injured his arm at work. Ted files a workers' compensation claim in your state. What is the process that Ted must follow in your state to file a workers' compensation claim? B. The claim is denied on the ground that the injury did not occur at work. Ted wants to appeal this decision of the agency. What are the procedural steps that Ted must file? Is there a time frame that the appeal must be filed in your state? C. Ted loses the appeal at the agency level after a hearing and wants to appeal that decision to a state court. What is the process that Ted must follow to appeal the agency decision to your state court? In your responses, use the actual names of the agency and courts in your state that would hear Ted's case. Provide all steps that should be included for your state's administrative appeals process. Provide citations to court rules, statutes, and forms that support what you include in your answer. If needed, you can add facts to Ted's story in order to cover more fully the litigation steps that could be involved at the workers' compensation agency and court levels in your state. Core skill ethics. 14.6a. In the Brown case, from this chapter, the attorney representing the insurance company deliberately withheld information regarding Clay's drug use and hospitalizations. Is this conduct ethical, and what action can Brown take against the insurance company? B. What ethics rules apply to the insurance company's actions? Are there any cases in your jurisdiction involving the deliberate withholding of discovery information from an opposing party in your state? If so, list all 3 cases that address the withholding of information by an attorney in a civil matter. Core skill computers. 14.7. Prepare a template for the following: A. A privilege log. B. A daily case tickler system for the attorney. C. An exhibit log to be used at trial. D. A template complaint for a collection case. Use a search engine to locate examples of these documents and find out how to set up the documents as a template using Word or WordPerfect. Core skill collaboration. 14.8. Using the facts in Chapter 14 from the Brown case as a guide, partner with 2 other students and prepare the direct and cross-examination in the criminal case for the following witnesses: A. Mr. Brown. B. The officer that found the heroin in Clay's car. C. Any witness that saw 1. When Mr. Brown was picked up by Clay, and 2. When the accident occurred. Be creative and use any additional facts that would assist in Mr. Brown's defense. The job search. A. Search online to find 2 job openings in your state for a Search online to find 2 job openings in your state for a litigation assistant, a paralegal who will assist attorneys in litigation. One of the openings should be for a paralegal with experience, and the other for an entry-level paralegal, someone with no experience. For each opening, list the duties and qualifications for the position. Give the websites where you found this information. Chapter Review. 14-9F. Portfolio Binder Assignment. The Brown case is set for trial in the civil matter. Your supervising attorney has instructed you to prepare the trial notebook for Mr. Brown, the plaintiff. Prepare the trial notebook for Mr. Brown based on your state's requirements. In this assignment, outline the general sections that would be used, and then for each section include the pertinent information that should be included. For example, if you have a section on witnesses, identify the witnesses, possible questions, and any exhibits that may be used by the witness in the case. or determine the possible voir dire questions you would ask prospective jurors. Additionally, determine the standard jury instructions in your state that Mr. Brown would submit to the court for consideration. Civil dispute. A legal controversy in which one private person or entity, like for example a business, sues another. B, a private person or entity sues the government. Or C, the government sues a private person or entity for a matter other than the commission of a crime. Criminal dispute. A legal controversy in which the government challenges the commission of a crime. Estate. All of the assets and liabilities of a descendant, one who has died at the time of their death. When we say that an estate is sued or brings a suit, we are referring to the descendant's representative who is authorized to resolve claims involving the descendant's assets and debts. For other meanings of estate, see the glossary. Jointly and severely liable. Legally responsible together and individually. Each wrongdoer is individually responsible for the entire debt or judgment. The injured party can choose to collect the full debt or judgment from one wrongdoer or from all of them until the debt or judgment is satisfied. Appearance. Formally coming before a tribunal as a party or as a representative of a party. The attorney usually appears by filing a notice of appearance in court of a praecipe. A praecipe is a formal request to the court, usually directed to the court clerk, that something be done. Attorney of record. The attorney noted in the court files as the attorney representing a particular party. Forum. 1. A court. 2. The place where the parties are presently litigating their dispute. 3. A court or other tribunal hearing a case. Venue. The proper county or geographical area in which a court with jurisdiction may hear a case. The place of the trial. Information and belief. Good faith belief as to the truth of an allegation, not based on first-hand knowledge. Prayer for relief. The request in a pleading for damages or other forms of judicial relief. Ad damnum clause. A clause stating the damages claimed. Subscription. 1. A signature. 2. The act of signing one's name. Verification. A formal declaration that a person has read a document, like for example a complaint, and swears that it is true to the best of their knowledge. Summons. A notice directing the defendant to appear in court and answer the plaintiff's complaint or face a default judgment. The summons is served on the defendant. Process server. Someone who serves or delivers process. Answer. The first pleading of the defendant in response to the plaintiff's claims. Defense. An allegation of fact or a legal theory offered to offset or defeat a claim or demand. Affirmative defense. A defense raising facts or arguments that will defeat the opponent's claim even if the opponent's allegations in the claim are proven. Contributory negligence. The failure of plaintiffs to use such reasonable care for their own protection as an ordinary prudent person would have used in a similar situation, thereby helping to cause their own injury or other loss. Cross-claim. A claim brought by one defendant against another defendant or by one plaintiff against another plaintiff in the same action, also called a cross-action. Third-party complaint. A defendant's complaint against someone who is not now a party on the basis that the latter may be liable for all or part of what the plaintiff might recover from the defendant. Third-party complaint. Adverse judgment. A judgment or decision against you. Pretrial conference. A meeting of the attorneys and the judge or magistrate before the trial to attempt to narrow the issues, to secure stipulations, and to make efforts to settle the case without a trial, also called a trial management conference. Scheduling order. A pretrial order of a magistrate or judge that sets time limits for discovery, filings, further pretrial conferences, and other related pretrial matters. Court reporter. The person who takes down and transcribes proceedings. Subpoena ducis tecum. A command to appear at a certain time and place and bring specified things such as documents. If ordered to give testimony, the subpoena would be a subpoena ad testificandum. If ordered to give testimony, the subpoena would be a subpoena ad testificandum. Summary judgment. A judgment of the court that is rendered without a full trial because of the absence of conflict on any of the material facts. A motion for a summary judgment is a request by a party that a decision be reached on the basis of the submitted documents and already agreed to facts without going through a full trial. Motion in limine. A request raised preliminarily, such as asking the court for a ruling on the admissibility of evidence prior to or during trial, but before the evidence has been offered. Bailiff. A court employee who keeps order in the courtroom and renders general administrative assistance to the judge. Jury panel. A group of citizens who have been called to jury duty. From this group, juries for particular trials are selected, also called venire jury pool. Voir dire. To speak the truth, a preliminary examination of A, prospective jurors for the purpose of selecting persons qualified to sit on a jury, or B, prospective witnesses to determine their competence to testify. Peremptory challenges. A request from a party to a judge asking that a prospective juror not be allowed to become a member of this jury without stating a reason for this request. Each side is allowed a limited number of such challenges. Peremptory challenges. A request from a party to a judge asking that a prospective juror not be allowed to become a member of this jury without stating a reason for this request. Each side is allowed a limited number of such challenges. Impaneled. Select and swear in referring to a jury, also spelled impaneled. Rule on witnesses. A rule that requires certain witnesses to be removed from the courtroom until it is time for their individual testimony so that they will not be able to hear each other's testimony. Sequester. 1. To separate or isolate a jury or witness. 2. To seize and hold funds or other property, sometimes called sequestrate. Sidebar conference. A discussion between the judge and the attorneys held at the judge's bench so that the jury cannot hear what is being said. Objection. A formal challenge usually directed at the evidence that the other side is trying to pursue or introduce. Direct examination. The first questioning of a witness at a hearing by the party who called the witness. Sustained. To uphold or agree with. Cross-examination. Questioning of a witness at a hearing by an opponent after the other side has conducted a direct examination of that witness. Redirect examination. Another direct examination of a witness after they were cross-examined. Recross examination. Another cross-examination of a witness after the witness has been through a redirect examination. Expert witness. A person qualified by scientific, technical, or other specialized knowledge or experience to give an expert opinion on a fact in dispute. Clerk. The court employee who assists judges with record keeping and other administrative duties. Exhibit. A document, chart, or other object offered or introduced into evidence. Arrested. To announce formally that you have concluded the presentation of evidence of your case. Case in chief. The main presentation of evidence by a party. Judgment as a matter of law. A judgment on an issue in a jury trial that is ordered by the judge against a party because there is no legally sufficient evidentiary basis for a reasonable jury to find for that party on that issue. Judgment as a matter of law. A judgment on an issue in a jury trial that is ordered by the judge against a party because there is no legally sufficient evidentiary basis for a reasonable jury to find for that party on that issue. Directed verdict. A judge's decision not to allow the jury to deliberate because only one verdict is reasonable. Judgment notwithstanding the verdict, JNOV. A judgment by the trial judge that is contrary to the verdict reached by the jury because the verdict was not reasonable in effect, overruling the jury. Prima facie case. A party's presentation of evidence that will prevail unless the other side presents more convincing counter evidence. Closing arguments. The final statements by an attorney to the jury or to the judge alone in a bench trial. These statements summarize the evidence presented during the trial and request a favorable decision. The final statements by an attorney to the jury or to the judge alone in a bench trial. These statements summarize the evidence presented during the trial and request a favorable decision. Jury instructions. A statement of law given to the jury by the judge for use in deciding the issues of the fact in its verdict. Also referred to as the charge to the jury. A statement of the law given to the jury by the judge for use in deciding the issues of fact in its verdict, also referred to as the charge to the jury. Declaratory judgment. A binding judgment that declares rights and obligations without ordering anything to be done. Motion for a new trial. A request that the judge set aside the judgment and order a new trial because the evidence is insufficient to support the judgment, newly discovered evidence, or errors committed during the trial. A request that the judge set aside the judgment and order a new trial because the evidence is insufficient to support the judgment, newly discovered evidence, or errors committed during trial. Stay. The suspension or postponed of a judgment or proceeding. Bond. An obligation to perform an act, like for example pay a sum of money upon the occurrence of a designated condition. Judgment on the merits. A judgment rendered after evidentiary inquiry and argument that determines which party is in the right, as opposed to a judgment that is based solely on a technical point or procedural error. A judgment rendered after evidentiary inquiry and argument that determines a judgment rendered after evidentiary inquiry or argument that determines which party is in the right, as opposed to a judgment that is based solely on a technical point or procedural error. Waived. To lose a right or privilege because of an explicit rejection of it or because of a failure to claim it at the appropriate time. Rehearing. A second or later hearing by a court to reconsider the decision it made after an earlier hearing. Appeal by right. The appellate of a case that an appellate court must hear, no discretion on whether to take the appeal. The appeal of a case that an appellate court must hear, no discretion on whether to take the appeal. Mandate. An order of a court. Execution. A command or writ to a court officer, like for example a sheriff, to seize and sell the property of the losing litigant in order to satisfy the judgment debt. Warrant. An order from a judicial officer authorizing an act, like for example the arrest of an individual or the search of an order from a judicial officer authorizing an act, like for example the arrest of an individual or the search of property. Prosecution. Bringing criminal proceedings against someone. Initial appearance. The first criminal court appearance by people accused of a crime during which the court A. informs them of the charges and of their rights, B. decides bail, and C. determines the date of the next court proceeding. Felony. Any crime punishable by death or by imprisonment for a term exceeding a year. Misdemeanor. Any crime punishable by fine or by detention, often for a year or less, in an institution other than a prison. Assigned counsel. An attorney, often in private practice or government public defender, appointed by the court and paid by the government to represent an indigent person in a criminal or civil case. Bail, money or other property deposited with the court as security to ensure that the defendant will reappear at designated times. Personal recognizance, release of a defendant in a criminal case without posting a bond based solely on a promise of the defendant to appear at all scheduled times, also called release on recognizance, ROR. Preliminary hearing, a pretrial criminal proceeding to determine if probable cause exists that the accused has committed a crime. Bound over, held or transferred for further court proceedings. Grand jury, a jury or inquiry, not a trial jury, that a jury of inquiry, not a trial jury, that sits for a designated period of time, hears the evidence of the prosecutor, and issues indictments when satisfied that a trial should be held. A jury of inquiry, not a jury trial, that sits for a designated period of time, hears the evidence of the prosecutor and issues indictments when satisfied that a trial should be held. Information, a document accusing the defendant of a crime. The document is issued by a prosecutor when a grand jury is not used or does not exist, also called bill of information. Nolle prosequi, not to wish to prosecute, a statement by the prosecutor that they are unwilling to prosecute the case. No contest, a plea that does not admit guilt, but that does not dispute the charge, so that it affects a plea that does not admit guilt, but that does not dispute the charge, so that its effect is a conviction, also called nolle contender, I will not contest. A plea that does not admit guilt, but that does not dispute the charge, so that its effect is a conviction, also called nolle contender, I will not contest. Plea bargain, an agreement whereby an accused pleads guilty to a lesser included offense or to one of multiple charges in exchange for the prosecution's agreement to support a dismissal of some charges or a lighter sentence, also called negotiated plea. An agreement whereby an accused pleads guilty to a lesser included offense or to one of multiple charges in exchange for the prosecution's agreement to support a dismissal of some charges or a lighter sentence, also called negotiated plea. Arraignment, pretrial criminal proceeding in which the defendant is formally charged with a crime and enters a plea. Acquitting, declaring that the accused is innocent of the crime. whole, to ask each member of a body, like for example a jury, that has just voted to state how they individually voted. Double jeopardy. 1. A second prosecution for the same or substantially same offense after acquittal or conviction. 2. Multiple punishments for the same or substantially same offense. Claimant. A person asserting or making a claim. Exhausted his administrative remedies. To go through all dispute solving avenues that are available in an administrative agency before asking a court to review what the agency did. Arbitration. A method of alternative dispute resolution in which the parties avoid litigation by submitting their dispute to a neutral third person, the arbitrator, who renders a decision resolving the dispute. Judicial arbitration. Court-referred or court-ordered arbitration. Contractual arbitration. Arbitration that the parties have contracted to use, also called private arbitration. Arbitration that the parties have contracted to use, also called private arbitration. Award. The decision of an arbitrator. Mediation. A method of alternative dispute resolution in which the parties avoid litigation by submitting their dispute to a neutral third person, the mediator, who helps the parties resolve their dispute but does not render a decision that resolves it for them. Med-arb. A method of alternative dispute resolution in which the parties first try mediation, and if it does not work, they try arbitration. Private judging. A method of alternative dispute resolution consisting of arbitration or mediation in which the arbitrator or mediator is a retired judge. Neutral evaluation. A method of ADR in which both sides hire an experienced attorney or an expert in the area involved in the dispute who will listen to an abbreviated version of the evidence and the arguments and offer an evaluation, also called case evaluation. Caption. The heading or introductory part of a pleading, court opinion, memo, or other document that it the heading or introductory part of a pleading, court opinion, memo, or other document that provides identifying information such as the kind of document it is, the names of the parties, and the court involved, if any. Notice pleading. A short and plain statement of the claim showing that the pleader is entitled to relief. Special damages. Economic losses, like for example, medical expenses and lost wages that must be alleged and proven. They are not presumed to exist, also referred to as specials. Special damages is a category of compensatory damages, which is money paid to restore an injured party to their position prior to the injury or other loss. Notice pleading. A short and plain statement of the claim showing that the pleader is entitled to relief. Fact pleading. Form of pleading that requires more detail when setting out allegations in a complaint, requires sufficient facts to establish a cause of action. Form of pleading that requires more detail when setting out allegations in a complaint, requires sufficient facts to establish a cause of action. Substituted service. An approved method of completing service of process other than by handing the process documents in person to the defendant or to the defendant's authorized representative, like, for example, service by mail or by publication in a newspaper, also called constructive service. An approved method of completing service of process other than by handing the process documents in person to the defendant or to the defendant's authorized representatives, like, for example, service by mail or by publication in a newspaper, also called constructive service. Affidavit. A written or printed statement of facts made under oath by a person called the affiant before someone with authority to administer the oath. A written or printed statement of facts made under oath by a person called the affiant before someone who A written or printed statement of facts made under oath by a person called the affiant before someone with authority to administer the oath. E-evidency. Evidence generated by or stored in a computer or other digital device. Examples include email, websites, digital spreadsheets, computer-generated memos, and other general evidence generated by or stored in a computer or other digital device. Examples include email, websites, digital spreadsheets, computer-generated memos, and other digital data. Depot summarizers. An employee whose main job is digesting, summarizing discovery documents, particularly depositions. An employee whose main job is digesting, summarizing discovery documents, particularly depositions. Bates stamp. A tool with which to manually or digitally insert a number, usually sequential, on a page. After using the tool on a page, it automatically advances to the next number, ready to stamp the next page. Page and line digest. A summary of a deposition transcript that presents the questions and the deponent's answers in the order in which the questions were asked, along with the page and line numbers where the questions and answers appear. A summary of a deposition transcript that presents the questions and the deponent's answers in the order in which the questions were asked, along with the page and line numbers where the questions and answers appear. Chronological digest. A summary of a deposition transcript that presents the events described in the deponent's answers in their chronological order. A summary of a deposition transcript that presents the events described in the deponent's answers in their chronological order. Topical digest. A summary of a deposition transcript organized by specific topics covered in the answers of the deponent. A summary of a deposition transcript organized by specific topics covered in the answers of the deponent. Shadow jurors. People hired by one side to observe a trial as members of the general audience gallery and as the trial progresses, to give feedback to the trial attorney who will use the feedback to assess strategy for the remainder of the trial. People hired by one side to observe a trial as members of the general audience gallery and as the trial progresses, to give feedback to the trial attorney who will use the feedback to assess strategy for the remainder of the trial. Moot court. Simulated oral arguments by attorneys prior to arguing case before appellate court. A mock session of appellate oral arguments. Simulated oral arguments by attorneys prior to arguing case before appellate court. Mock session of appellate oral arguments. Judgment debtor. The person who loses and therefore must pay a money judgment. Judgment creditor. The person who wins and therefore has a right to collect a money judgment. Contempt. Conduct that defies or disrespects the authority of a court or legislative body. When the court is defied or disrespected, it is called a contempt of court. Conduct that defies or disrespects the authority of a court or legislative body. When the court is defied or disrespected, it is called contempt of court. Subpoena ducis tecum. A command to appear at a certain time and place and bring specified things such as documents. If ordered to give testimony, the subpoena would be a subpoena ad testificandum. A command to appear at a certain time and place and bring specified things such as documents. If ordered to give testimony, the subpoena would be a subpoena ad testificandum. Impaneled. Select and swear in, referring to a jury, also spelled impaneled. Warrant. An order from a judicial officer authorizing an act, like for example the arrest of an individual or the search of property. Information. A document accusing the defendant of a crime. The document is issued by a prosecutor when a grand jury is not used or does not exist, also called bill of information. A document accusing the defendant of a crime. The document is issued by a prosecutor when a grand jury is not used or does not exist, also called bill of information. E-evidence. Evidence generated by or stored in a computer or other digital device. Examples include email, websites, digital spreadsheets, computer-generated memos, and other digital data. Moot court. Simulated oral arguments by attorneys prior to arguing case before appellate court. Mock session of appellate oral arguments. Judgment debtor. The person who loses and therefore must pay a money judgment.